there is an endorsement of not found.
Not found, not is not that. No such postal report was there. Then your lordship directed to serve on the learned advocate, the lower court.
Yes.
Of the. That's why you have served in terms of your lordship's order.
Yes.
And you have acknowledged.
Yes. Achha.
Acknowledgement is there. Rest is. Second paragraph, Milord, your lordship's order is reflected. I'm grateful, my lord.
Lordship, may I permit to mentioning for inclusion, my lord? The second appeal.
Second appeal.
Second appeal, my lord.
Any application pending?
No, my lord.
Ready for hearing?
Yes, my lord. My lord, the matter was heard on 2022. My lord, heard on the 4th of July 2022. And
by a different bench.
Yes, my lord, Justice Basu. But given direction, the matter will be listed on after 1 week after Puja vacation. But the matter is not running.
Paper book? What about the paper book?
No, paper book is required. Paper book is not ready.
Trial court record?
Trial court record is have.
You have been served notice?
Yes, my lord. Served notice.
No. You have been served notice that the trial court record are okay?
No, my lord. But it's
Mr. Bhattacharya, assist her. Thereafter you come.
yes.
রিপ্লাই দেবো আবার তো
ছোট বই
বলেনি কি বলছো
বড় বই আছে
আসুন
Nobody is there for the respondent.
I was to give reply. They have completed. Let them come. Let me start.
At least
Yes, yes.
advocate on record.
ভোট দেখাচ্ছে তো চলে আসবে But let me, my lord, recapitulate the refresh your lordship's memory, my lord. I have,
In the meantime,
argued, my lord, at least 3 weeks back. মিনিট 15 করি আমি রিপ্লাই দিচ্ছি
আচ্ছা শুনুন সাইটেশন গুলো ট্রায়াল করে as regards to that
may I know, my lord, lordship's query from me?
The fact is that the assistant of the doctor could not name the doctor's name during his submission, and
that's why, my lord, I relied upon 72 Supreme Court.
And the other point is that you have produced only one
medical certificate issued by the doctor.
Not a prescription, but a medical certificate in this regard.
Yes, there, my lord, my submission relying upon, my lord, 72 Supreme Court was when the signature has been admitted, contents will automatically go into evidence. In a case like this, where the defendants could not bring out any, could not produce any independent witness to disprove that fact.
And you have relied upon 2025 SCC online,
Yes.
Supreme Court 1961,
Yes.
paragraph 33,
Yes.
onwards.
Onwards.
1972, one Supreme Court cases, page 9, paragraph 20,
Para 20. Yes.
and 2022, volume 18, SCC, page 489, paragraphs 18 and 19.
For section 54 of the Transfer of Property Act. Now, my lord. Yes. Now, two things, my lord. First, my lord, my learned friend, my lord, had taken, my lord, two basic objections. First, kindly see, my lord, what were the substantial questions of law framed. Kindly see, my lord, 5th October 2018, my lord, order. These were the two, my lord, specific, my lord, objections, my lord, which were taken by my learned friend. Kindly see whether both the court
No,
below.
substantial questions of law, 4 substantial questions of law.
Exactly. Miller, kindly see one, whether the learned, both the courts below substantially are in law and facts by dismissing the suit filed by the plaintiff appellants without considering the material evidence on record.
General one.
This is a general material evidence on record. Now, my lord, my arguments, my lord, regarding 54 of the Transfer of Property Act or 58 of the Registration Act, these are, my lord, consequences of my argument. My lord, my lord, specific grounds need be. If, my lord, the material evidences were there, what would be the consequence of my case in view of those provisions of the Act? My lord, I don't think, my lord, for that, my lord, additional substantial questions of law is required to be framed. However, to avoid this, I have, my lord,
we have
prepared.
just started. Not forward, but backwards.
Your arguments only.
Recapitulation.
Now, my lord, but for
Recapitulation of my submissions.
Entire.
I have already, my lord, prepared, my lord, additional substantial questions of law, my lord, which will appear, which are not, my lord, away or deviating from my original pleadings. These were very much there in my pleadings, my lord, to make it less complicated to answer the my lord, issue properly. I have prepared that.
Additional substantial questions of law at this point of.
Yes, my lord can.
No.
Yes, kindly see section.
After completion of hearing, they have completed this submission.
Yes, I'll satisfy your lordship. I'll satisfy. Kindly similar section 100 of the.
Then in that case, they will have to be given the opportunity.
They have already argued on 54 and 58. They have already argued there.
No. The question is whether now at this stage additional substantial question of law can be.
Learned counsel. It can be framed. It can be framed.
Yes, can be. But at this stage,
we cannot say that it cannot be framed. It can be framed, but the fact is that you shall have to be given the opportunity to submit on that issue.
I have something to say. After the conclusion of hearing, it should have been, my lord, before starting of the arguments by both the parties.
That should have
in my respectful submission, my lord.
That should have been, but
after conclusion of hearing, my lord, it is something.
But I'll show to your lordship.
We have not. We have still now not concluded.
Exactly. Because
he has completed. I have completed. It is his turn to reply only on point of law.
Instead of raising that issue at the time of reply, that should have been raised at the time of hearing.
Hearing, my lord, I tell your lordship, my points would be not, my lord, will not deviate, my lord, from the points answered by my learned friend.
But,
I have already taken, my lord, the points of 58 and 54 in my argument. For that, my learned friend has given reply, and my lord, he has even shown judgments to that. Therefore, my lord, parties know what points they have to meet. I am to, my lord, to obviate, my lord, this so that no technical point arise. My lord, I am only, and that too, my lord, have only brought that. My lord, kindly see, my lord. Shall we go?
has copy been served?
Well, I am given copy, my lord.
I think is additional substantial question of law.
Kindly see, my lord, section 100, subsection 5.
It is not
So,
permitted.
Bhattacharyji,
Yes.
ultimately there will be 8 substantial questions of law
No.
if these 4 are
Added, or this may be modified even. This may be modified because lordship has seen, my lord, after hearing, after issues are framed in suit, after evidences are led, it is quite, my lord, it is natural after amendment of pleadings are done, issues are recasted during trial.
Everything is correct, but we shouldn't, when we have got the opportunity, we
Very
had
well.
the opportunity.
Yes.
We should have,
I'm not misusing the opportunity. Kindly see, my lord, my questions. It will, both the parties have already argued that. I am only saying this, my lord, not to go into any technicalities. Kindly see, when the evidences adduced by the defendant's witnesses clearly show that admitted consideration amount of the impugned deed has not passed on the vendor, whether the learned judges of both the courts below substantially are in law in coming to an erroneous condition, the entire consideration money has been passed to the vendor. I have already argued that.
this
Yes,
same issue
one
has been
one
dealt with the issue number 1. Substantial
yes.
question number
Then
1.
Mira, kindly see, Miller, this is
That is an overall one. You have specified it.
only to supplement, nothing else. These are, while learned friend has already argued that. Kindly see number 2, when it is apparent from the argument currently 54.
No, I will give reply
Ah,
because it is
very-
in the form of additional substantial question of law.
Yes. When it is
Now,
apparent,
let us see whether these 4 are
this is supplement.
at all required to be added or not.
Exactly.
These are beyond the substantial questions of law already framed or not.
Exactly. Number 2, kindly see, Miller, when it is apparent from the documents exhibited by the parties and the evidences led by the defendant witnesses that consideration amount has not been passed by the vendor, whether the learned judges of both the courts below substantially are in law by not holding that the impugned deed is vitiated due to non-compliance of the formalities of section 54 of the transfer of property. Both the parties have already argued on that. Even, my lord, I have relied upon judgments. My learned senior friend has also relied upon judgment, distinguishing my judgments on this. Therefore, arguments have been led. Then, number 3, when the registrar had not given any endorsement regarding passing of the consideration amount to the vendor, it should be to the vendor in the impugned deed, which is mandatory requirement under section 58 of the Registration Act, whether the learned judges of both the courts below substantially are in law by not holding that the impugned deed is vitiated by fraud. I have argued that, cited judgments. My learned senior friend has also cited judgments on this. There is no fresh hearing necessary on this. Next, whether the judgments and decrees passed by the learned judges of both the courts will be liable to be set aside on the ground that they are perverse or has been passed without considering the materials available on record. This again goes back to substantial question number 1, which has already been formed by the. These are specific. Now, my lord, kindly comes to page 9 of the paper book. I want to show that these points were taken in the pleading itself.
Mr. Shane.
Yes.
Mr. Shane, as regard to the substantial, additional substantial questions of law,
Yes.
what to be submitted, which have been
First-
placed today.
My first submission is this, that after conclusion of the arguments by both the parties, when it is the stage of giving reply on question of law only, not on even fact, there cannot be a reframing of any additional substantial question of law. It could have been done. Recording reasons. before,
This court agrees with you, it could have been done, but the
at
proviso
this
is that,
stage cannot.
proviso is that whether at this stage, after giving opportunity to the respondent, whether it can
No,
be added
in
or
my
not.
respectful submission, it cannot be because the hearing is, in my submission, it is not permissible in law because the arguments of both the sides is complete.
In spite of having the opportunity to argue on these issues,
Complete. Opportunity given, complete.
you have completed.
Now, no, I say that my learned friend has completed his
He
argument.
has completed.
I have also completed.
No.
Now he is trying to give reply.
If the opportunity is given to the respondent, then among these four additional substantial questions of law, can anything or
Is left
two
out. Is left out to be
can be
argued.
added or not, if opportunity is given to you, specifically you,
My lord, in my respectful submission, it is not permissible.
not permissible. Then we will have to open the CPC. It's a shame to cut short the matter from this end
I am with your lordship
to
because
from this end-
it fell from your lordship.
from this
Then
end,
that-
let specific section 54 of the Transfer of Property Act, but he has stated
2 and
that
2 and 3.
Whether the learned judges of both the courts below substantially erred in law by not holding that the impugned deed is vitiated due to non-compliance of the formalities of section 54 of the Transfer of Property Act, and the other one, when the registrar had not given an endorsement, as regards to section 58 of the Registration Act.
Let him give reply, not in the shape of additional framing of additional substantial question of law.
These are already in my argument.
Let it be.
Yes.
Let it be. I don't mind, but not in the shape of framing additional substantial
case-
question of law. That they are my objection.
In that case, this court specifically adds the section 54, which has not been mentioned in the substantial questions of law already framed, and section 58 of the Registration Act. Apart from that two, nothing more
Yes.
At
Two-
this stage.
2 and
at
3.
this stage.
My lord,
And you will be given the opportunity. You have already submitted, but in spite of that, keeping
Then your
aside that
lordship
one,
kindly fix another date, my lord. I have not come prepared, my lord. Moreover, my lord, I have, my lord, some personal problem. I have
Let me complete.
because
Let him
I
give
tell you,
reply on the
lordship,
next day.
what is the situation? I tell you, lordship.
in that case, you won't get any other further
No,
opportunity.
I don't. I will
You
complete it
you
today
complete
itself. Yes,
today?
yes.
On the next day, next Friday, you give your any
I know.
reply as regards to section 54 of the Transfer of Property Act and 58 of the Registration Act.
My learned friend has already given that. These are my not new arguments. I have started my arguments. on
So
this.
let his
Once-
reply be.
Once these two sections are being introduced specifically, he has to be given the opportunity.
Definitely.
This situation wouldn't have arisen if the additional substantial questions of law would have been placed at the time of hearing
Definitely.
initially.
No, hearing is not finished.
Recording reasons.
Only
Now, Miller kindly takes up Miller two
this
things.
portion, whether the learned judges of
2 and
both the
3. 2
courts
and 3.
below,
2 and 3.
two second part, whether the learned judges of both the courts below substantially erred in law by not holding that the impugned deed is vitiated due to non-compliance of the formalities of section 54 of the Transfer of Property
Yes,
Act.
yes, yes,
This part,
yes.
because this will be dealt, this one has to be dealt.
Already dealt. Already dealt according
Then-
to him as he
And already replied also by my learned
And-
senior friend.
And as regards to section 58 of the Registration Act.
না সাইড টক করছেন কেন আপনি তো নেই এই মামলা আপনারা বকে যাচ্ছেন কেন দাঁড়ান
No, everybody is waiting for his turn,
Yes,
and
yes.
he is waiting
Very anxious.
for several days to get the opportunity. Yes, learned counsel.
Yes. Now, my lord, kindly takes up, my lord, page 9 of the paper book.
अच्छा नींद सो पेपर बुक में दाम the learned counsel representing the appellants submits that 4 additional substantial questions of law need be framed, and to that effect he produces the 4 substantial questions of law. Full stop. On going through the suggested additional substantial questions of law for the ends of justice, as Section 54 of the Transfer of Property Act and Section 58 of the Registration Act, Indian Registration Act, shall be dealt with while coming to the final conclusion. So, these 2 additional substantial questions of law are being framed. Bole, inverted comma ভিতর additional substantial questions of law. এক নম্বর হচ্ছে whether the learned judges of both the courts below substantially erred in law by not holding that the impugned deed is vitiated due to non-compliance of the formalities of Section 54 of the Transfer of Property Act. And the second is whether you will get the opportunity whether they had raised it before the trial court or before the first appellate court or not. That is also very important. Second হচ্ছে additional substantial questions of law. Section 80, whether the learned judges of both the courts below no শুনুন the courts below হবে না, below কতটা হবে না, the trial court and the first appellate court, courts below জায়গায় whether both the courts, that is the trial court and the first appellate court, whether both the learned judges, that is the first that is the trial court and the first appellate court, erred in law by not holding that the impugned deed is vitiated by fraud as regards to non-compliance of Section 58 of the Indian Registration Act.
Honorable, kindly record my submission. And kindly record my submission. That
As the learned counsel representing the respondents has raised the objection as regards to framing of the additional substantial questions of law
at this stage.
At this stage, Mr. Bhattacharya,
Yes.
please.
Now, my lord, kindly.
No, place that.
Acha, 100. 100. Subsection 5. ছোট বই নেই
Subsection 5 provision.
That is there. Whether at this stage,
ও আচ্ছা
for that, this one is required.
Yes. 5 is, may I please, my lord?
Hmm, okay.
5, subsection 5. The appeal shall be heard on the question so formulated, and the respondent shall, at the hearing of the appeal,
Hmm.
I repeat, at the hearing of the appeal.
Hmm.
At this stage, my lord, the hearing is at the stage of giving reply to my submissions, to the submissions made on behalf of the respondents. Hearing is almost completed. At the hearing. Hearing is concluded. He'll just give reply in law, not in fact.
As per settled law, the scope of exercise of the jurisdiction by the High Court in second appeal under section 100 is limited to the substantial questions of law framed at the time of admission of the appeal, or additional substantial questions of law framed at a later date after recording reasons for the same. It was observed in Santosh Hazari's case that a point of law which admits of no two opinions may be a proposition of law but cannot be a substantial question of law. To be a substantial question of law, it must be debatable, not previously settled by law of the land, or a binding precedent, and answer to the same will have a material bearing as to the rights of the parties before the court.
Kindly record my submissions. Then in my turn, I'll make my submissions.
The learned counsel representing the respondents raises objection as regards to the framing of the additional substantial questions of law at this stage, full stop. In the opinion of this court, as additional substantial question of law can be framed at any time of the hearing, subject to the opposite party, that is the respondent, given the opportunity to reply as regards to the additional substantial questions of law, it can be framed at this juncture also. So, we'll have to stand up from 11 to 2 a.m.
Let my learned fellow conclude his argument today. My learned junior will be here. Hello. On the next date,
Next Friday.
next Friday. May be on 13th, my lord.
Huh?
Next Friday is 6th. May be on 13th.
Okay. It's a problem.
Yes. Another matter has been
Yeah.
fixed, my lord, in the morning, 6th.
Well, it's the 13th.
Although it is unlucky 13, no problem.
At this juncture also.
With your lordship's kindness.
So today Mr. Bhattacharya is concluding.
Yes, yes.
Everything
be
is being
concluding?
concluded
I'll
only
be.
on these two additional substantial questions of law.
And I'm assuring my learned friend, I'm not giving any new judgments, my lord, on 54 and 58. Whatever arguments, my lord, I've made judgments, I will only distinguish his judgments, my lord, today. That's
Yes,
all.
that you have the opportunity.
That's
in
all.
reply.
Now, my lord, my lord has already, my lord, read the passage, my lord, for your lordship's convenience. I had brought copy of Santosh Hajari.
Acha, acha.
2001, volume 3 SCC. 179. Volume 3 SCC, 179. But I knew, my lord, this objection would have arisen, my lord, 60, paragraph 16, 17, 18. My lord has already read from the.
In spite of knowing, did not produce at the time of at the initial stage.
That this is, my lord, Santosh Hajari.
Hmm.
Next, my lord, what I would be placing, my lord, these were all these pleadings where they are argued before the trial court. Evidences were laid, but I could not find any reflection in the judgment of the first appellate court.
Written notes were filed.
Written notes, my lord. I do not have the copy, my lord.
Before the first appellate court.
দেখি LCR টা আপনি ছিলেন LCR টা দেখি
ট্রায়াল কোর্টের রেকর্ডটা এবং ফার্স্ট অ্যাপেলেট কোর্টের রেকর্ডটা দিন আমাদের
from the judgments it is apparent
there was discussion there is discussion
in the trial court,
not
in the first appellate. Kindly comes to page 9.
issue
Yes,
দেখি
kindly see
একবার দেখি
the paper book.
আচ্ছা পেপার বুকে আছে page number
Page 3 of the paper book.
page 4
Pre-Millard issues is the suit maintainable in the present form, is the cause of action for instituting the suit, have the plaintiffs have right title and possession over the suit property as alleged in the plaint. 4 is the alleged sale deed dated 31st August 1998 is vitiated by fraud and undue influence. My lord has just, that is the language just now my lord has framed. 5 are the plaintiffs entitled to the relief as spread for. 6, what other reliefs are the plaintiffs entitled. Regarding 58, however, no issue was framed. However, arguments laid and that was countered. Kindly comes to page 9 of the paper book, trial court judgment. But appeal court is completely silent on that. Kindly see the last paragraph. Learned advocate appearing on behalf of the plaintiff submitted in his argument, that is my client, plaintiff, that the instant deed was executed under suspected atmosphere in favor of the person who was absolutely not related to Haranala. He submitted that there was no endorsement by the sub-register to the effect of rupees 10,000 was given in his presence. This is section 58 of the Registration Act. This was taken, point was taken. Then, my lord, I'm coming to 54. He argued that the document that is exhibit revealed that Haran Allah died of prolonged illness. His argument was that Haran Allah was
you are placing
page 9, my lord, the last paragraph.
Yeah.
The learned advocate appearing on behalf of the plaintiff submitted.
That is as regards to 58 of the Registration Act.
Exactly.
And 54?
That paragraph.
Continuation. He argued.
Yes, he argued that the document under Exhibit E revealed that Haranala died of prolonged illness. His argument was that Haranala was a literate person and he put his LTI on the said deed. It would be presumed that he had no strength at all to put his signature. He added that there was no endorsement in the deed, that the same was registered on commission. It was further contended by him that the evidence of the doctor was of not much value since Haranala died within 1 day of execution of the deed. He contended the inter alia that the death certificate did not show the death cert did not show that he died of heart attack. He further submitted that the deed did not contain the fact the defendants paid rupees 10,000 on that date and they paid rupees 40,000 on previous occasion. This is Millard section 54 of the Millard Transfer of Property Act. Entire consideration amount was not paid. Point was taken. The appeal court is completely silent on this. It was taken. For your lordship's recapitulation, I will be placing the evidences already placed. Only few parts, for your lordship's recapitulation.
Need not.
Very well.
Only the law points.
Very well. Only since so long, we have. That's why to refresh your lordship's memory, that is there. I have nothing to. Nothing because this is already placed. You are only for my satisfaction. This is what I wanted.
No further.
Now, in that case, kindly see, another judgment. This is on the general principles of substantial questions of law. General principles. It would be required for formulation, because why today, due to formulation of today's substantial question of law, because this is not on the merits of the case.
কি করলো এটা যাচ্ছে এখন ফরম্যাট তো হয়নি আমাদের অবজেকশন করতে দ্যাটস অনলি দিস হাউ উই হ্যাভ গিভেন দ্য নিউ জাজমেন্ট
What has been done till now?
No, this has been giving our objection to the subject question of
You
law.
have raised your objection. The objection has been dealt with, and two substantial questions of law have been framed, and you have been given the opportunity to argue on that 2 points of additional substantial questions of law. That will be submitted on 13th by your learned senior.
2020 volume 20 SCC 199. Kindly see. Yes. 2022 volume 20 SCC 199.
2022 volume
20 SCC 199. Kindly comes from paragraph 32.
What does it state?
Yes. Which? উঠুন দেখুন এখান থেকে সাইটেশনের নাম চন্দ্রভান ভার্সেস সরস্বতী। Kindly comes to the principles relating to section 100 relevant for this case as summarized. That kindly comes to 32.2, which is at page 210. Kindly see the High Court should be satisfied that the case involved a substantial question of law and not a mere question of law. A substantial question of law having material bearing to the decision of the case, that is question answer to which affect the rights of the parties to the suit, will be substantial question of law. Therefore, rights of the parties here will be affected if the deed goes. Plaintiff's right will be established. If it is not covered by any specific provision of law or settled legal principle emerging from binding precedents and involves a debatable legal issue. A substantial question of law will only arise in a contrary situation where the legal position is clear either on account of express provision of law or binding precedents, but the a court below has decided the manner either ignoring or acting contrary to legal principle. Here, my lord, acting contrary to legal principle, I say the appellate court, my lord, he has not adhered to any principle at all. My lord, better to say the trial court has discussed the issue at least. Legal principle in the second type of cases, substantial question of law arises not because the law is debatable, because the decision rendered on a material question violates the settled principle of law. But this is definitely violates the settled principle of law. Then 32.3 is very, very important. The general rule is that High Court will not interfere with findings of facts arrived at by the courts below, but it is not an absolute rule. Some of the well-recognized exceptions are where the courts below have ignored material evidences or acted on no evidence. My lord, I am squarely covered by one. Number two, the courts below have drawn wrong interference from proved facts by applying the law erroneously. Number three, the courts have wrongly cast the burden of proof. When we refer to the decision based on no evidence, it only refers to cases where there is total dearth of evidence. My lord, we are not covered by that. 1 and 2, my lord, I am strictly covered by 1 and 2. Now, my lord, why, my lord, I rely upon this judgment? My lord, kindly see, my lord, my learned senior friend had relied upon one judgment. Interfered with why, my lord, I am relying upon this. 99 Supreme Court, page 2213. My learned senior friend has relied upon one judgment, my lord, on the last occasion, AIR 1999 Supreme Court 2213, para 4.
Respondents have relied upon
1993, volume 3, SCC 722.
you have relied upon three judgments. First
Yeah.
council,
Yes.
three. 1970 AIR 1977 Odisha 178.
Yes.
Paragraphs 11, 12, 13.
Yes.
AIR 1994 Kerala 308.
Yes.
Paragraph 186.
185, 186,
185,
and
186.
186.
And in the case between Arun Kumar Banerjee, judgment in the case between Arun Kumar Banerjee and another
60 Calcutta, 61 Calcutta,
the state of
62 Calcutta.
62 Calcutta, page
504.
504.
AIR 1962 Calcutta, page 504,
504. Para 46.
paragraph 46.
Yes. Now, my lord, kindly see, my lord, this is the judgment which my learned friend relies upon. Kondiba Dagaru Kadam, 1993 volume, 1999 volume 3722, or my lord, AIN 99 Supreme Court 2213. বলেছিলেন তো my note says, my lord, this was relied upon.
Learned counsel, I think at that point of time, the hard copy was not provided.
Yes, ma'am, white, yes.
আমের মধ্যে নেই।
1993.
99 volume 3 SCC 722, or in AIR it is AIR 99 Supreme Court 2213. দেখালেন তো নাকি হার্ড কপি দিয়েছিলেন? বই দিয়েছিলেন নিয়ে
As regards to which issue?
yes, concurrent finding of facts under section 100.
Hmm.
Sorry.
Yeah.
AIR or SCC, anyone will
SCC?
do. SCC Millard, 1999, volume 3 SCC 722.
1999,
Volume
Volume
3 SCC
3.
722.
722.
Before Justice Shagir Ahmed and Justice R.P. Sethi.
Yes.
Kindly comes to paragraph 4. Millard, this is my note says so. My learned friend had relied upon paragraph 4. Kindly see. He has.
It has been noticed time and again.
Yes. It has been noticed time and again that without insisting on the statement of such substantial question of law in the memorandum of appeal and formulating the same at the time of admission, high courts have been issuing notices and generally deciding the second appeals without adhering to the procedure under section 100 of the Civil Procedure Code. Therefore, as of today, Millard, procedures have been adhered to. The Civil Procedure Code. It has further been found in number of cases that no efforts are made to distinguish between a question of law and a substantial question of law. In exercise of the power under this section, the findings of fact of the first appellate court court are found to have been disturbed. It has to be kept in mind that the right of appeal is either natural or inherent right attached to the litigation. Being a substantive statutory right, it has been to a regulated in accordance with the law in force for the relevant time. The condition mentioned in the section section must be strictly fulfilled before a second appeal can be admitted, and no court has the power to
Counsel.
add or to
Lord Counsel, you should at least regret.
I have not talked much.
No, not to you, to him. When hearing is going on, how could you loudly speak? Yes.
The second appeal cannot be decided on mere equitable grounds. The concurrent finding of facts, however erroneous, cannot be disturbed by the High Court in exercise of power under this section. The substantial question of law has to be distinguished from a substantial question of fact. This court in SIH Sir Chunilal such and such has dispersed. My learned friend had laid too much stress on these three lines. The concurrent finding of facts, howsoever erroneous, cannot be disturbed by the in exercise of the power. Therefore, this is not an absolute rule.
Corresponding to AIR 1999 SC 2213. Yes. They have relied upon.
For that, to Miller to counter this is on the principles of substantial. I have relied upon Miller 2022 volume 20 SCC, Miller page paragraph 32 onwards. That is not an absolute rule. Three Miller criteria have been carved out by the Supreme Court, which says these are the three criteria on which Miller substantial question of law can be framed. and the judgments of the trial court and the first appellate court can be set aside if it falls within the exceptions, those through exceptions. Otherwise, it is a general rule, substantial concurrent finding of facts cannot be interfered with. But there are 3 exceptions. That's why, this is not on the merits of the case. I am submitting on the principles of section 100.
But that also takes us to the merit also.
Definitely, but this is on the principles. This is there. Now, if your lordship would kind enough to come to, the judgments, which my learned senior friend had relied upon. First, one I have already now distinguished. This 99 Supreme Court, this is already over. Now, 77 Odisha, page 178.
The hard copy has not been provided of that one. 1999.
My learned friend had brought the book on the last occasion.
Hard copies of 3 judgments only. AIR 1962 Calcutta, the Odisha one, AIR 1977 Odisha, and AIR 1994 Kerala.
I'll provide on the
Provide the hard copies. Yes. Yes, Mr. Bhattacharya.
Yes, kindly see, Odisha, 77 Odisha, 178. My learned friend had relied upon, so far as I can recollect, paragraph
13.
11, 12.
And 13.
13. Very well. 11, 12, and 13. Now, kindly see, what are the, what is paragraph 11, 12, and 13? Kindly see. This is, on section 58, of the Registration Act. Kindly see, simply because there is 12, the scribe of exhibit B has also said that according to the instruction given by the vendors, the contents of the documents were written out. The evidence read with the contents of the document clearly supports that the question of passing consideration, the evidence read with the contents of the document clearly supports that the question of passing consideration. Now, in our deed, if your lordship would once again see, the original deed, one stray sentence has been recorded, 40,000 টাকা পণ গ্রহণে দান করলাম. But the most distinguishing feature between our case and the reported judgment is, here, the suit was filed by the vendor himself, who was alive at the time of date of the suit, filing of the suit.
In this case, the vendor has expired.
Exactly so. Exactly so. There, in that occasion, Honorable Odisha High Court has said, since the vendor has appeared, is deposing, whatever the registrar says or doesn't matter. When he is appearing before the court and deposing, I am taking his.
Yes, he has received the money.
He has received the money. I am taking it as face value. Whether the registrar has given it or not given it doesn't matter, because that is a technical aspect. But this is the distinguishing feature. This is not fitting in the facts.
And the other 2?
Yes. Now, kindly takes up the mandatory directory. 1993 Supplementary 2 SCC 611. But may I once, before going to their judgments regarding 77 Odisha, I will be, recapitulating, your lordship's, mind with my 2025, kindly allow me to place that again.
You have already placed.
Only, paragraph 37.
Need not.
Very
well. Now you will be dealing with AIR 1962, Calcutta.
No, 1993 Supplementary 2 SCC 611. Interpretation of statute.
1993 Supplementary 2.
Yes. Kindly see, para 19, which my learned friend has relied upon.
Hard copy নাকি এখানে মাত্র 3টে আছে,
এটা
দেখুন 1993. Learned Counsel, you had provided the hard copy of this one.
Oh, yeah, again I'll put on. In course of that, I'll provide one.
Ah,
Yes.
The 1993 and the AIR 1999. That too. Yes.
Yes, my বই নেই ও আচ্ছা 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 তো সফট কপি আছে
Oh, yes. No, data slow. Ashok Kumar Sharma versus
অশোক কুমার শর্মা versus
Chandrasekhar.
চন্দ্রশেখর
Mhm.
Justice T.K. Thomas.
Paragraph 19, they have
Yes,
relied upon.
before that, my learned friend had relied upon the head note, the fourth head note interpretation of statutes.
We'll be going by the contents.
We will be going. My learned friend has relied upon. That's why. Yes, kindly goes to the contents. Yes, kindly see Millard 19.
Yes.
It is on Millard mandate. কোনটা দেখিয়েছিল? Yes, kindly see Millard the last few lines. On the middle of that Millard paragraph, it says the mandatory character of possessing the requirement.
Using the requirements as
Yes.
provided in the
Yes,
first
as
part.
provided in the first part of the notification stands further strengthened from the third and the last part of the notification, which prohibited the candidates from applying if they did not possess the requisite qualification. In view of this, the clear and specific condition laid down in the advertisement of those candidates which are not possessed of the BE qualification are not eligible for applying, not their applications were liable to be entertained, nor could they be called for interview. Eligibility for the post mentioned in the notification depend on possessing the qualification noted against each post. The expression shall be possessed of such qualification is indicative of both mandatory character of the requirement and its operation in presenti. That it is a candidate must not only have to be qualified but should have been possessed of it on the date of the application was made. The construction suggested by the learned counsel of the appellant that the relevant date for purpose of eligibility was the date of interview and not on the date of application or July 15, 1982. The last date of submission of form is not made out from the language of the notification. Acceptance of such construction result in altering the first part of advertisement prescribing eligibility of the date of applying for the post as being extended to the date of interview. If it is read in the manner suggested, then the requirement is that incomplete applications and those not accompanied by the requisite certificate shall not be entertained shall become meaningless. Purpose of filling certificate along with application was to prove that conditions required were satisfied. Non-filing of any certificate would have resulted in not entertaining the application as required, as specified would have been presumed to be non-existent. Fulfillment of condition was mandatory and its proof could be directory. This was what was my learned friend harping upon. The former could not be waived or
Procedural lapse, not mandatory,
exactly
is directory.
yes.
What he has emphasized.
Yes. Now Millard kindly takes up the Registration Act. I'll show Millard whether it is directory or mandatory. First of all, Millard, the judgment, Millard, is not applicable to this case on two occasions. First, this judgment does not deal with a provision of non-compliance of a statute. It was dealing with a provision of
As regards to application being
exactly, which is a ministerial act, not a non-compliance of a statute. Now, Millard, kindly see again 58(1)(c). This is what I am harping on. Any payment of money or delivery goods made in the presence of registering officer in reference to the execution of the document and any admission or receipt of consideration, the whole or in part made in his presence in reference to such execution. This has to be endorsed by the registrar. This has to be endorsed by the registrar in view of the fact that DW4 has clearly stated out of 40,000, 30,000 was given and the remaining 10,000 was given to Mr. Allah in presence of the registrar. It was their witness only. Lordship, that's why, Millard, I wanted to, Millard, recapitulate your Lordship's memory on Millard DW4. Lordship would kindly recapitulate that.
Need not.
Now, Millard, why I say this is mandatory? Kindly comes to section 60, subsection 1. After such of the provisions of section 34, 35, 58, kindly marks. After such of the provisions of section 34, 35, 58 and 59 as applied to the documents presented for registration have been complied with. I am on compliance of section 58 and 58 means 58 as a whole, 1A, B, C. Complied with. The registering officer shall endorse thereon a certificate containing the word registered together with the number of pages and page of the book in which the document has been copied. Therefore, if the formalities in section 34, 35, 58 and 59 were not done by the registrar, he could not have made an endorsement in the deed that it has been registered. This shows, Millard, section 60 shows the compliance of section 34, 35, 58 and 59 are absolutely mandatory. Otherwise, he could not have, Millard, given the Millard the stamp registered.
Anything more?
Yes, Millard. Now, Millard, kindly comes to Millard. No, Calcutta, 60 Calcutta. AIR 1962 Calcutta 504.
Paragraph 46.
42. My notes says
46 has been relied upon.
46. Very well.
Mr. Doctor also argued that medical evidence.
Yes. First of all, Millard, kindly see, Millard, the very first paragraph of the judgment after the Honorable Judge's name. The second line. What was the court dealing with? Section 302 of the Indian Penal Code. Millard, a criminal trial is, Millard, proceeds on the basis of, Millard, beyond reasonable doubt it has to be proved. Civil trial proceeds or preponderance of probability. Millard, whether my lord, this judgment, my lord, at all on that, my lord, my lord, formulation, my lord, of law, my lord, that can be applied here. Now, my lord, kindly comes to, my lord, 42 or 46. Okay, 46. My lord, 46 is not even there in the judgment.
No. Till 49.
Yes. আমাদের ওটা 42 তে আছে।
They have provided AIR.
My paragraph starts with 42 with Mr. Dotto.
No,
Mr. Dotto
Dotto
also it's
argue.
in SCC volume it's 42.
42.
The medical evidence was not conclusive in this case, but this criticism does not help the appellant. We have already discussed in the medical evidence is hardly conclusive and decisive because it is preliminary and evidence and opinion and not of fact. That was what Lord such and such has relied upon. Now, my lord, kindly recapitulate, my lord, again the death certificate.
Yes, relied upon, we have to consider not merely medical evidence, but also the other evidence and circumstances appearing on the point.
Exactly.
That has been relied.
Other circumstances. Then, my lord, kindly see, I have only, my lord, given the medical prescription given on from our part, and which was duly proved by the Mr. Omio Ghoshal, the compounder of Dr. S.K. Banerjee.
Medical certificate.
Medical certificate.
That cannot be said as a prescription.
Not cannot be. But here, my lord, my judgment, my lord, which I have relied upon, 72 Supreme Court, clearly, my lord, comes, my lord, on the my lord, saves me. It says when the Mr. Ghoshal, my lord, had clearly admitted in his cross-examination that he knows, my lord, the signature. This is his signature. This was given by Dr. Ghoshal, my lord, at the time of in his presence. He is very much aware of that. ওই প্যারাগ্রাফটা একবার বার করো 72 টা।
Once a document is properly admitted, the contents of the document are also admitted in evidence, though those contents may not be conclusive evidence.
Exactly. Why here it is conclusive evidence? Because on the contrary, you could not bring any other evidence or any other witness to disprove this fact. Therefore, once, my lord, the signature, handwriting, everything is admitted, and it is my lord, exhibited after recording objections, you cannot say that cannot be treated as a conclusive evidence. That cannot be.
And as regards to 1994 Kerala, paragraph 185, 186.
Yes.
They have
Same as
relied upon.
62 medical certificate. এটা আছে ওনার কাছে একটা কপি আছে 94 কেরালা নেই তো খুলে গেছে পেয়ে গেছি আমিও পেয়ে গেছি
Expert opinion gets its weight and authority when the expert puts before the court all the materials which induce him to come to the conclusions, so that the court, although not an expert, may form its own opinion on those materials. Opinions must be supported by reasons, and it is the reason and not blank finding that is important.
This is also a criminal case. This is also a criminal trial. This is also a criminal trial. First, secondly, my lord, criminal trial, my lord, regarding leakage of ammonium sulfate and ammonium chloride, my lord, how far this matches with the facts of this case, lordship has to look into it. Only, my lord, picking up, my lord,
Hazardous industry.
My lord, on that, my lord, it is not there. Lord, kindly, my lord, for this, my lord, I will kindly allow me to, my lord, place, my lord, paragraph 37 of 2025 is for last, my lord, two judgments. So, দুটো একটু দেখিয়ে দাও, দিয়ে শেষ করে দেবো। That evidence part, my lord, I am not, my lord, troubling your lordship.
Paragraph 33.
No, 35. 30, yes.
33 onwards.
Yes. Kindly see,
You
my
have
lord.
relied upon that.
Yes. Basically, my lord, kindly see, my lord, 37
Hmm.
due to to counter mirror that Odisha judgment 77 Odisha. Kindly see the endorsement made by the sub-register at the time of execution of the sale deed thus reads the contents of the sale deed have been read over and explained and read over and understood to Ram Saran Saran 2/3 share, Rizali 1/3 share, and Bhatgawat husband to Vendi. They have verified the same and the vendors have received rupees 6,000. Kindly see, this is compliance of section 58. Vendors have received 6,000 from the husband of the Vendi in presence of the sub-register. Both the parties have identified by Madhav Singh, Sarpanch, and witness number 2, Bondhu. Then Milord, kindly see 38. Concurrent finding of both the first appellate court and the high court indicate the husband of the defendant, that is one Bagdawat, who was allegedly given the remaining sale consideration of 6,000 during the time of execution of the sale, had not stepped into the witness box. Furthermore, one of the attesting witness of the execution of the sale deed, that is Sarpanch, has also died before the deposition and could not be recorded. One Bondhu, who has the second attesting witness, was the father of the defendant, and both the courts have doubted his testimony being partial to the defendant. There was no witness who could substantiate the case of the defendant. There was part payment of sale consideration of rupees 6,000 during the time of execution of the sale deed. Here, Milord, why I refer to this judgment, Milord, DW1, who is the purchaser? Milord, kindly recapitulate what he has stated. First, he has a business, he has a factory of opticals, not a mere business. Factory, he has bank account, he has not produced it. He specifically stated, court bolle ami debo. This
ultimately not produced.
Not produced. He stated he has balance sheet of business, not produced. He stated
only oral evidence.
He stated that he had the agreement was entered into between him and Mr. Ala 1 month prior to his death, and since he could not give the money at that point of time, he had given it part by part. 30,000 out of 40,000. He has stated he has not produced, Milord, his source of money. And a specific question was put into, was there any witness who will prove this fact? He said that there is no other witness. There is no other witness. Therefore, this Supreme Court thus says that you could not prove your source of money. Even the registrar here, 58C, was complied with. That's why I placed section 37. Thereafter, also, Honorable Supreme Court set aside the judgment of the High Court and said that that deed is a product of fraud. Number 2, there is no money receipt, my lord. There is no memo of consideration in the deed. My lord has taken note of that. There is no memo of consideration. Who is writing the deed? The moharar. The law clerk is writing the deed. He says
Deed writer.
Deed writer, and he was the moharar of the, yes, deed writer, scribe, whatever may be. He is writing. He says পণ গ্রহণে 40,000 টাকা পণ গ্রহণে দিল। The vendor was not in a position to see what has happened. Oh, another part is the DW1 has specifically stated in his in his affidavit in chief, he was in a fit mind, capable and understanding what he was doing, and he was physically fit. And he also, Milord, goes to the extent that আগের দিন তিনি নিজে রান্না বান্না করে নিজের বাড়িতে খেয়েছিলেন. This is the specific statement. The additional, both in additional WS and in the Milord affidavit in chief. This is the specific statement made. If, Milord, that be the case, then what was the, Milord, occasion, Milord, for Mr. Ala to, Milord, sign on the deed, or not to put the LTI and not to sign? If he was so physically fit and mentally fit, what was the occasion? One. Number 2, DW4 here stated.
Now, Mr. Vadaja, you are going back to fact.
Very well. This is
already complete.
This is 2022
we could have concluded today, but
ওইটা একবার দেখিয়ে দাও।
Lord Council on
30.
First at the top it will be.
And my lord, another judgment, my lord, which I had already relied upon, that is 2022. এটা একবার এ করে দাও, লাস্ট ওইটা একবার শেষ করে দিচ্ছি। আরেকটা দেখানো হয়েছিল, দেখানো হয়েছিল, দুটো জাজমেন্ট দেখিয়েছিলাম, 25 আর একটা কেবল কৃষ্ণান, কেবল কৃষ্ণান। Keval Krishnan, cost title is 2022 18 SCC 489. Down there, like you ছিল, হ্যাঁ?
Paragraph 18 and 19.
Yes.
You have provided.
Yes. My lord, the paragraph 18
and 19. Need not reiterate.
yes, without kindly comes to 19, para 19.
You already.
You have relied
Yeah,
upon.
already. আমি পড়েছি তো, paragraph 18 onwards.
The learned counsel representing the respondents.
That only one thing, let it be made clear that my learned friend will not show judgments on the merits of the case. If he wants to show on substantial question of law, that is only permissible, not on the merits of the case.
No. Only for
Again he will come up with again on merits of, no. I will only relied upon
only section 54 of the Transfer of
no,
Property Act.
only on the whether it can be formulated, because I have not relied upon any new judgment. On whatever judgment is there, and he has only controverted that.
Section 54 of the Transfer of Property Act
and
and
section
section
58
58
Act.
of the Registration Act. Is his submission? Full stop. Paragraph. As at this stage, and but as at the time of reply, the additional substantial questions, two additional substantial questions of law have been framed in respect of as regards to the issue of section 54 of the Transfer of Property Act and section 58 of the Registration Act. So the learned counsel representing the respondents is given the opportunity to submit on these two additional substantial questions of law only. And on the next day, let the matter appear on 13th of February, or on 13th of February, written notes of argument be provided.
Unless I hear, my lord, what they, my lord,
আর কি রিপ্লাই করব রিপ্লাই কি রিপ্লাই
ঠিক আছে, এই কটা দিয়ে করে দেবো।
Parties will be at liberty to file written notes of argument.
13 that top 13 that top
At the top it will be.
can it be at 2 p.m.
Time cannot be set.
My lord, mine is item number 2. Hope my lord will be sitting after after the division bench is
There is
over.
another bench of mine, division bench at 12 noon.
Yes.
So
Yes.
next matter. I don't know what to double. At 2 p.m. once again at 2 p.m. But let us commence item number 2.
Item number 2, my lord, I am appearing for the petitioner virtually. My lord, this matter has been assigned before your lordship. It's a service matter, my lord. Group 6 matter. There was a direction to file, my lord, affidavit in reply and affidavit in opposition. Kindly permit my
1 minute, Lord Counsel. The last order is dated And you are representing Learned Council, you are
I
representing
am for the Union of India.
Union of India.
Well, I am submitting the.
No, my lord,
affidavit.
kindly permit my intern junior to file the affidavit in reply also, my lord. That is, since I am appearing virtually, kindly permit my intern junior to hand over the my lord, affidavit in reply,
Learned Council,
my lord.
in the courtroom, there is nobody to represent the petitioner apart from you appearing virtually.
No, my intern junior was there, my lord, with the affidavit in reply. Very well, my lord. Miss Shreya Banerjee was there, my lord. She was standing in, I can see, second standing Shreya Banerjee. Kindly hand over the affidavit in reply to my lord's officer once.
May I permitted to file the
1 minute. Learned Council,
My lord.
It's not proper job.
I'm extremely sorry, my lord. I don't have any practicing junior, my lord. She will not stand here. She will go back, my lord. Only for handing over the documents, my lord, kindly permit her. That's it.
Learned Council, in this situation, in this circumstance, are you in the court premises?
No, my lord. I'm outside Kolkata, my lord. No, my lord, that doesn't matter, my lord. I'm ready to argue, my lord.
The fact is that the affidavit in reply, neither a junior, at least a junior
I
should
know,
have
my
been
lord.
present.
I know, my lord. Kindly excuse me for this, my lord. On the next occasion, my lord, I'll be there in court. But for today, my lord, I tender apology, my lord. Since I don't have any practicing junior, my lord, and this is, my lord,
It is upon the bar. What to be done in this situation
Only question was to
as regards to receiving the affidavit in reply?
affidavit reply. He is not. He is not.
affidavits are complete, my lord. Only the heading is to be done by my lord.
It is being
unfortunate, my lord. The
Learned
person
Council,
concerned.
Learned Council, it is being
Out of decorum, there.
nothing.
Yes. দিয়ে দিন
স্যার আপনি অপোজিশনটা দিতে
আপনি শিখতে হবে তো ওকে জুনিয়র হলেও তাকে জুনিয়র তো নয় সে
ইন্টার তার তো ওর তো কোনো ভুল নেই
You have filed the affidavit in opposition.
স্যার
Let the affidavit in opposition file. Affidavit in opposition to again in.
এটা নিন আমার
Copy has been served of the affidavit in reply. You have received the copy of the affidavit in opposition.
Yes. All are done, my lord. Everything is complete. Only the hearing will be done by my lord. My lord, let me open my case, my lord.
Learned Council, there's a bench at 12 noon. So the matter will be taken up at 2 p.m.
No, minute. I have some difficulty. I have to leave the court. 2 p.m. will have some difficulty. Next week, any day.
So, have you heard it?
I have.
So, affidavit.
My lord, junior, my lord, my learned friend's junior is also assigned by the Union of India. She can be here, my lord. She don't have to argue. She will take only note. She will only take the note.
The affidavit in opposition.
Because I have some urgency in this matter, my lord. Kindly see the assignment letter, my lord. I have spoken to the officer on special duty of the Honorable Chief Justice, my lord. Considering the urgency, my lord, the matter has been assigned before your lordship, my lord. What I submit, my lord.
She is also impaneled.
Yes, she is also impaneled. She is appearing since 2024, my lord. Let her take note.
They can wait for.
Let her take note. She don't have to argue. She don't have to argue, my lord. Let me complete my argument at 2 p.m.
It will be better. It will be better to hear both of you on the same day. Let the matter appear on 6th. 6th of February.
6th February.
If it is my lord, if it falls from my lord, I don't have. I cannot say anything, but my lord, she can take note. She is also engaged.
We are missing our bus.
Let her do something also at least.
Affidavit in opposition has been filed on behalf of the Union of India. An affidavit in reply on behalf of the petitioner has also been filed. Let both the affidavits be kept with the record. Full stop.
Kindly keep it at the top, my lord, on 6th.
Second item, না কি বলে ওই 6 তারিখ এটা ফার্স্ট আইটেম at the top
I'm grateful, my lord.
here on 6th of February at the top.
Great.
On the submission of the Learned Council representing the Union of India. ঠিক আছে? He seeks an accommodation.
The next matter, I am for the petition.
Learned Council. This bench will be available from 2 onwards, 2 p.m.
Well, after the division, there is no indication in the list that she will sit again. That is the difficulty. Then on 6th, second item. I'm ready today.
No. এই সেকেন্ড হাফে বসো কি বলে
Can it be if your lordship members?
Second item, I'm ready today.
We are ready. We are
We are
waiting.
waiting. Yes, some difficulty. Yes.
I have some question.
On 6th, second item.
See.
Item 3. I'm ready today. Waiting from the morning.
আপনি এদিকে আসুন।
I'm second item. Oh, no, 6th. Civil division.
Yes,
My lord. I'm for the petitioner.
What is the matter involving?
Well, defendant petitioner, suit filed by the plaintiff.
both the parties.
Let the matter appear on 6th of February.
At second item. Second item. Well, because I'm ready. Kali mentioned this matter. I'm ready to do the case. It is not.
I'm also waiting since.
I'm grateful. I'm extremely grateful. I'm extremely grateful to Lordship.
Much obliged.
I'm extremely grateful.
Your Lordship permits me, At 2 p.m.
I was
There's a bench. There's a division bench.
I was supposed to mention a matter, my lord.
There's a division bench now. At 12.
At 2 p.m., my lord is ready. Great.
2 weeks ago, my lord directed me to serve the copy of the application upon the other side. I have served, they have received, but they did not turn up. In the meantime, they have constructed. The fact is that a civil suit was filed by us, my client.
No, where is the notice served? And where is the
Yes.
mentioning slip?
Yes, yes. This is the notice.
Mentioning slip?
This is notice. Mentioning slip is with me, but BSNL has actually replied that they have received. And if you also kindly go through the same. Kindly go through the same. But I have not suppressed anything,
No, no question of suppression arises, but the procedure is to be followed. That is the
Yes,
fact.
this is the first page.
When a learned counsel submits, it is sacrosanct for the institution. That is not the fact. The fact is that the procedure is to be followed.
They have received at least 50 times they have received the notice and they did not turn up. In the meantime, they have constructed. Civil suit was filed by us. We lost. Thereafter, appeal court. We lost. Thereafter, appeal court. Here, they actually turned down the order passed by the civil court, and ultimately that was allowed. And thereafter, paper books have been prepared, and everything is ready, and file is live. If you lordship kindly so direct
The respondents are being represented by
Joyanto Mondal.
Joyanto Mondal,
Yes.
learned advocate.
Yes, sir. He resides in Uttarpara. From Uttarpara, we have
No,
posted-
where from? Where from it delivered? আচ্ছা এটা স্টেপল করে এটা স্টেপল করে নিন সব থেকে মেনশনিং স্লিপ নিয়ে নিন ঠিক আছে সেটা উপরে থাকবে এটা স্টেপল করে মেনশনিং স্লিপ হবে স্টেপল করে বুঝেছেন স্টেপল করে আনিয়ে নেবেন
I'm giving
yes,
instruction. Let it appear now. Let them come.
Let the record first come. নিন ডাকুন
Item number 4. I am for the petitioner, my lord. In the last occasion, I have submitted affidavit of service, but your lordship was not pleased to hold as a correct and further afresh service. I have afresh service on 2nd January, on that day, when the lordship was pleased to. And
served it
yes, my lord, all
Sent
respond. Yes, and
served or sent which one
some means in the by post because it is
you
a
have
private
sent it.
party. Yes, my lord. And 27th, I have received the track consignment of the Indian Post. I served on this means the sent on 2nd January. On that day, the lordship was pleased to ask afresh service.
You have sent on
Four.
the 2nd of January.
Four.
How many
4, my lord.
how many opposite
Opposite
parties
party,
are there
4.
one Abdul Bari
Died and substitute by substitution 4.
1A 1B 1C and 1D
Yes, ma'am.
all have been sent.
Yes. All sent. That's it.
Fact is that the track report reveals that item delivered, but Sri Krishnapur BO, that is
I have waited, my lord, 25 days. And what can I do, my lord? Kindly consider the procedure. Lordship knows the Supreme Court says the procedure will not come in the. In, not Lordship knows.
But without having informed, can a
My
matter
lord,
be
earlier affidavit it also that. And your lordship was not pleased. I have filed earlier affidavit of service. Then again, 25 days I wait. And my lord, kindly see the date, 27th. 25 days I have waited. 25 days. No development will come.
Had anybody represented prior to
No,
the matter being dismissed?
No, my lord, when they dismiss for default, none appears. Yes, my lord, page, last, my lord, 15 page order, none appear.
Order dated?
Order dated
22/5.
22nd May 2024. The cause is that learned advocate died on the cause of COVID. I am the transfer, believe me. I am not the advocate on record. It is a restoration application, man.
Nowadays, the track reports aren't showing that it is being delivered to the incumbent learned councils.
No one appeared. And the matter is not other side appeared, my lord.
No. The fact is that learned
He is my
council from
junior.
the track learned council. The fact from the track report earlier, it could have been found that whether the incumbent has received or not. Item delivered upon Mr. A, item delivered to Mr. B. But nowadays, the track reports do not reveal that the item has been received by, but delivered to that person.
Whether it has been received by the
Delivered to the sendee or not.
It is hands of the postal department, my lord. 25 after 25 days, my lord.
That is not the fact. That is, the general fact is that it is not helping the institution. We are facing the trouble.
Subsequently, if the incumbent come and say that we
item this one, see,
reach to us.
Item received Habra SO. That does not mean that item has been received by the sendee.
And I ask myself that what can be procedure can be done as the it can be proved that sent to them. 25 দিন পরে তুলেছি আগে একবার দিয়েছি আবার 25 দিন 2 তারিখে আমি দিয়েছি 27 তারিখে ট্র্যাক রেজাল্ট তুলেছি 25 দিন 25 days ওদের তো 7 দিনের বেশি রাখার নিয়ম নেই এমনিতে 7 days within 7 days otherwise return.
My lord, if the section 16 of the general clause applies, if it is same correct address, then
that can be presumed.
Yes. Otherwise, it is the bona fide of the applicant that he can show that yes, we have discharged our duty as directed by the court by sending it to the sending in his correct address as available from the post address.
This one is the first affidavit of service or second one?
This is the second.
Earlier one is dated.
Yeah,
this one is
my lord,
January.
I have submitted, my lord, earlier occasion. 2nd January, I have submitted, my lord.
Yes, no, 4th December.
Yes, my lord. 4th December, my lord. And sent
4th December.
21st November, sent. And all parties, earlier all parties.
When dismissed on
22nd May
2024. And restoration application?
Yes, my lord. 26th March 2025, because beyond the knowledge that advocate died, the petitioner does not know. The petitioner is 85 years old. I have stated, my lord, it has been stated in the paragraph number 11, page 8, that the petitioner is 85 years old, and his son generally look into the matter. He was outside for working, and when he came 21st March 2025, he found that the house or the residence of the learned advocate is under lock and key. Nobody was there. And he searched about what is the cause. Then it has been found that he died on COVID.
Then 26th of March.
Yes.
What were you doing for the last 10 months from 22nd May to
I have stated, my lord,
March
that
25?
relied upon the learned advocate. He said when he was living that I shall ask you when it required. And his son is working outside the state, and he is 85 years. He cannot go.
Is it the duty of the learned counsel to intimate the client, or it is the duty of the client to get information from the learned counsel?
In general, my lord, 2019 it has been filed, and 22 it has been dismissed. So generally the business of the court generally permit unnecessary communication is not required. And for that reason, and liberal view should be taken, my lord. I am praying, and lordship knows, if your lordship want to see that is relating to the COVID, the Honorable Supreme Court judgment is there, lenient view will be taken.
That one is not required.
And even in the date of knowledge, if your lordship want to see the date of 2001, Supreme Court says from the date of knowledge it will be counted. So from the date of knowledge, no delay. I have my judgment. If your lordship wish to see, then I can hand over. From the date of knowledge, 6 days earlier.
None of the track reports reveal that it has been received.
The lordship is correct, but my lord, it is out of our hand.
What to be done?
It is out of our hand. I do not know, my lord, what can be the procedure. Lordship asks me, I again serve on that very day. 2nd January, lordship was pleased to pass order. And on that day, I have said.
That you are submitting, but from this end, let us take for consideration, it is restored. Thereafter, your adversary comes up.
On merit, they will not be paid. If your lordship consider, they will not be paid on merit. I am praying on merit that the revision should be hard on merit. There will be not be prejudice in otherwise in the substantive right. The substantive right should not be prejudiced. On merit hearing, if I have no case, it will be lost.
That is not the question, hearing on merit or not. The question is whether they have received or not. That is the question.
They are avoiding me. I may presume they are not interested. They are avoiding.
To that effect, there are other endorsements also.
5 years has passed, my lord. Kindly consider 2019 and now about 7 years. This is for default after 5 years. 5 years. If they interested, they may search in the High Court website.
What is the matter about?
Matter about is specific performance
Of
of the
contract.
contract. Yes, my lord. That land purchasing, advance paid, and
How much you have paid?
80,000 is contract, 65 paid. Landed trial court was
In
pleased
which year? In which year?
1995. I am in the possession. Possession has been delivered. I am in the possession.
You are in possession?
Yes, my lord.
Then learned counsel, serve once again.
My lord,
Yes.
again,
No,
if
no.
it come again,
Then you are not being prejudiced. I mean, from the actually learned counsel representing the petitioner, the petition. Petitioner files an affidavit.
yes,
of
my lord,
service.
trial court was pleased to pass decree in favor of me. And 15,000 will be, the balance 50,000 will be paid and it will be registered. Direction is there, decree. Thereafter, they want to set aside the order. As they are firstly appeared, they have a
Affidavit of service. From the affidavit of service, it is not clear whether the respondents have received or not. That's because from the 3 track reports, it transpires that the item has been delivered at Sri Krishnapur, SRI SHNAPUR, Sri Krishnapur BO, while the 4th track report reveals that the item has been received at Habra Eso, HABRA, Habra Eso. That's from the affidavit of service. The track report, it is not transpiring that the that the opposite parties have received the same. Full stop. Full stop. In such circumstance, the learned counsel is directed to serve once again upon the respondents and to furnish the affidavit of service and furnish affidavit of service. Let the matter appear. Address is Ashok Nagar. Let the matter appear on 20th February.
maybe.
20th
I
February.
have no problem.
20th February.
My lord, kindly, my submission, kindly mention the delivered date mentioned in the track result, 5th January. Kindly
only-
mention, my lord. I shall be obliged.
Only the date has not been mentioned, but where it has been delivered in respect of all.
Yes,
it has been mentioned.
yes.
has been mentioned.
Lordship has mentioned Sri Krishnapur BO, but it is seen that on 5th January.
Let the affidavit of service be kept with the record.
Kept with the record, my lord. But 5th January, that is report, 21 days ago.
If this time nothing happens, then
And
next
if
step
it has
will be
not
taken.
come back, that if he reflects that will come back, then return to sender. That has not mentioned, my lord. Return to center has not been mentioned.
In the meantime, if you obtain the full report of this one, you can also place with the next one. In the meantime, if you are able to obtain.
Yes, my lord. My presumption why it will not done,
Lord
because
Counsel,
their mandate is
let us
7 days. 7 days mandate.
Let us take up the
Either
next matter.
return or deliver.
Item number 5 and 6.
My lord, this is a harassment of a poor person, my lord. Nothing but. It will come again, same.
For the proceed party, my lord, I am suffering a blanket order of stay. Decree holder irrigation. I am the decree holder in respect of his title suit 190 of my lord 1995.
For the opposite party.
I am for the opposite, but I am
Who is for the
suffering a blanket order of stay.
The petitioner, my lord, my senior is arguing in a different bench right now. So I'm going for a short possible.
My lord, kindly see this sort of prayer prior to puja. This sort of prayer is coming whenever your lordships took up the matter.
Last
If it-
order.
My lord, kindly have a look on it before
Opposite
puja.
parties,
It appeared, my
are
lord,
being represented by
no representation.
being represented while none is representing the petitioners, judgment debtors. When the matter is taken up for hearing. What is the matter about?
My lord, I obtain an ex parte decree. My lord, that
Degree.
ex parte decree, and my lord, the
How you obtained the ex parte degree?
well, since my lord, defendant after receipt of my lord respective summons, if they fail to turn up, or if they not choose not to turn up, not to contest the suit, then my lord, court has no option but to pass ex parte decree.
No.
My lord, my lord,
They had, in spite of receipt of summons.
Yes.
In spite of receipt of summons, they did not appear.
Yes. They
Suit
choose
for-
not to
Suit
appear.
for
Suit for declaration and injunction. My lord, it is the plaintiff with me. My
declaration
lord.
as to
My lord, declaration that I obtain the property by way of inheritance from my father. From my father, the co-scheduled property. My lord, so the defendant having no right title interest over the same, I am enjoying
who is
this.
the defendant? Who is the defendant?
My lord, defendant
No.
from
Is he the adjoining landowner or something else?
adjoining landowners. They had no right. My lord, this is the expiry decree. My lord, let me read.
What disturbance was he creating?
They are offering my peaceful enjoyment of the co-scheduled property. Co-scheduled property. My lord, it is the plain case that
Having 11 DAG numbers.
yes. It is more fully provided in the, my lord, schedule of the plaint.
93.64 decimal.
Yes. Total, my lord, cost schedule and cost schedule. In cost schedule, my lord, there are 1 acre 94.5 decimal cost schedule, and cost schedule, my lord, in total, my lord, 11 acres 67 decimals, and my lord, in cost schedule 9 acres 64 decimals. This is the, my lord, schedule of the property, my lord. My lord, contention in the application under section 47 is, my lord, kindly, if your lordships once, my lord, kindly go through the order impugned, that is order dated 18th October 2023. My lord, kindly have a look. Order number 129. It's a 1-page order, my lord. Today is fixed for hearing of petition dated 6th September 2023. Both the parties file Hajira. Now the petition dated 6th
Order dated
18th October 2023, order impugned in this revisional application CO 1513 of 2024.
This CO 1513 is before your lordships. 1513 of 2024.
Yes, 1513 of 2024.
2024. My lord, kindly have a look to the order impute.
1 minute. 5 and 6. 6 is 2814 of 2024.
2814, my lord, is subsequent to this CO, after continuance of the blanket stay order, they filed, my lord, another CO, my lord, without servicing any copy upon the decree holder, the present opposite parties. My lord, kindly have a look to the impugn order of CO 1513 of 2024.
1513 of 2024. Dated in
18 October 2023.
18th October 2023. Apart from that order, each and every order is being found.
Is just actually helpful. 15-13 ওটা নেই জোসেফ পাচ্ছেন না 15-13 15-13
অর্ডারটা কোথায়? Fifteenth,
13th
13th.
of 2024. CO 15-13 2024.
No. Impugned order dated
Dated 18th October 2023.
18th October 2023 order. Cool.
হ্যাঁ এইটাই তো বলছি
18th October 2023. Yes.
Yes. এটা এখন রাখুন এটা পরে করেছে আমাদের উপর সার্ভিস হবে জানি my lord the order speaks for itself. Today is fixed for hearing of petition dated 6 September 2023. Both parties file hajira. Now the petition dated 6 September 2023 is taken up for hearing. The petition dated 6 September 2023 is a stay petition prayed by the petitioner. The learned advocate for the petitioner has stated that defendant number 6, namely Bindu Bala Mondol, had expired on 13th February 2003, and defendant number 8, namely Montu Dhali, had expired on 5th June 2019. But the title suit number 190 of 1995 was decreed expiry on 15 January 2009. Thus, the title suit number 190 of 1995 stands abated. The advocate for the defendant has raised vehement objection to it. At this stage, the court finds TS 190 of 1995 has already been decreed expiry in the year 2013
2023.
এটা ভুল করেছে এটাও ভুল নেই the petition judgment debtor had come before this court to abate the expiry decree. At this juncture, petitioner judgment debtor had no locus standi to make such prayer.
This case is under order 9 rule 13.
No,
Then?
it is 47. Their contention in 47 since
47.
Yes, their contention since two
Did
defendants.
not file order 9 rule 13.
Order 9 Rule 13, they might have filed. They filed another suit. What they done? After having this decree, they filed one suit challenging the expiry decree. They- that is here. That is here. I am coming one by one.
Filed another suit.
Another
challenging the
suit.
expiry decree.
Yes, yes,
That has
yes.
been entertained.
Yes, yes, entertain. That is here. I am coming to that. There is a judgment of Honorable Justice Soposaji
Where's the
Bhattacharya.
senior?
In
Where is the senior?
My lord, he is in court number 25.
Let him be present at 3 p.m. Ask him to be present at 3 p.m. Otherwise, necessary order will be passed.
and my lord, we are suffering a blanket order of stay. There must be a limit of the stay, ad interim order of stay. It should be disposed of. I want disposal of the CO because I am unnecessarily being harassed.
The matter will be taken up at 3 p.m. রাখুন 3টের সময় ডাকবেন If none is present at 3 p.m., necessary order will be passed.
Item number 7.
Your name. Ready. Next.
Item number 8.
What is the matter
For
about?
the petitioner, your lordship have come up against an order of interim injunction, temporary injunction, passed in a suit. Your lordship will kindly see the plaint case is one, the court has,
Temporary injunction.
yes. Miss Appeal have filed, that was also dismissed, I have come up here in revision. The plaint is completely different, the order passed is something else. Kindly see the plaint. What is the claim and
You
what
are
is
representing all the opposite parties.
My lord, I am representing 6.
Representing opposite parties number 1 to 4.
My lord, we'll see the last order. Opposite party number 5 has
expired.
5 has expired.
In compliance with-
son is there on record. So
Kishori Devi,
Yes, yes. I am for 6.
widow of late Hariyal Sharma. His wife
yes,
has been
Both.
substituted.
wife and son was already on record.
No, my lord, son was on record.
Om Prakash, I think Om Prakash.
Yes, respondent number 6. I appeared on the last day.
He is already on record.
On
As
record?
such, the wife has already been has been substituted.
Yes. I'm
So
for
you are you are representing the sons.
6 and the wife.
5 and 6. Why are
5.
5A
yes,
and 6?
5A and
5A and 6.
5 and 6.
So why you have said that you are representing 6 only?
No, my lord, I thought that whether it has been
So
carried out or not.
all are being represented.
Yes.
Yes.
Now, your lordship will kindly come to the plaint. What is the plaint case?
Plaint.
Plaint and injunction. That is at
Suit for declaration.
yes. Kindly come.
An establishment.
Your lordship, it's a short plaint. I'll place the plaint and then your lordship will everything.
No, plain. Place it.
Page 18, your lordship.
Page 18, yes.
1-8. Your lordship has got that? The plaintiffs herein are the legal heirs of late Devaki Sharma, being Dharmavati Sharma, wife of Devaki Sharma, Bharat Bhushan Sharma, Kamal Sharma, Manoj Sharma, being the sons. On or about September 1982, a tenancy agreement was entered into between one Madanlal Jhunjhunwala, son of late Anand Ram Jhunjhunwala, and late Devaki Sharma, son of late Aklu Sharma, with regard to one shop room measuring 17 feet by 12 feet situated on the western side of the of the boundary premises and the plot number so and so. By dint of the said tenancy agreement, the said Madan Lal Junjunwala has kept a security deposit in the year September 1982 for rupees 3,400 for such tenancy, and further 250 rupees as monthly rent was fixed with regard to the said trade. At that juncture, the wife of late Devki Sharma was a housewife and sons were minor. Devki Sharma used to do business on and from 1982 from the said premises of welding of different materials. Slowly and steadily in the year 1999, Devki Sharma had started his business of lathe by purchasing different materials from one DB machine tools. The said Devki Sharma had purchased the said machinery from DB machine tools of one Vidhan Sarani, Calcutta 73. Then your lordship, paragraph 5. The total cost of machinery as on 13/8/1999 was 1,60,000 along with sale tax. Then the plaintiff states, paragraph 6 onwards is the relevant. The plaintiff states that on or about 2000, the said respondent number 1, Horil Sharma, alias Haril Sharma, who appraised the father of the plaintiff number 2 to 4 and the husband of plaintiff number 1 to do some supervisory work under him. Your plaintiff states that the respondent number 1 used to do the supervisory work under the husband of plaintiff number 1 and father of plaintiff number 2 to 4. At that juncture, plaintiff number 1 was the housewife and plaintiff number 2 to 4 were minors. The father of the plaintiff number 2 to 4 and husband of plaintiff number 1 had a trade license in the name of Sharma Engineering Wires. Your plaintiff states that the late husband of the plaintiff number 1 and father of plaintiff number 2 to 4 died on 7/10/2010. After the death of the husband of the plaintiff and the father of the plaintiff number 2 to 4, the opposite party number 1 used to supervise our business. Thereafter, his son, Om Prakash Sharma, used to supervise the business of the plaintiff. The plaintiff states that thereafter, 6-7 months, a mere quantity of money, around 7 to 8,000, for supervising such business was paid to the plaintiff number 1. Thereafter, it was stopped completely by the defendant number 1. The defendant number 1 was running the business unlawfully of the plaintiff herein out of the firm of the plaintiff from 7/1/2010. Your lordship will note this date, 2010. The lathe machines of plaintiffs, the plaintiff being the owner of the said business, was deprived from being paid a single penny. The defendant number 1 continued to use the lathe machinery and business whose owners are at present the plaintiffs herein. The said business cannot be run illegally by the defendant numbers 1 and 2 continuously. The plaintiff being owner of Sharma Engineering Wire, situated at Delhi Road, Chaumatha, intends to close down the business. The plaintiff states that the plaintiff number 2 to 4 on or about 13 March 2020, before the COVID-19 lockdown, went to the said premises and tried to put a padlock on the said shop. Your lordship, this is the cause of the plaintiff. The plaintiff states that when the plaintiffs tried to put a padlock at the said premises, immediately the defendant number 1 and 2, in connivance and conspiracy with defendant number 3, tried to resist the plaintiff. The said defendant further threatened the plaintiff with dire consequences of life. The plaintiff states that on 29/1/2019, also the plaintiff tried to put a padlock on the said premises, thus closing down the said shop room. The plaintiffs declare that they are owner of Sharma Engineering and Wires. Under no circumstances the said defendant number 1 and 2 forcibly and or illegally, unlawfully be permitted to run the business and earn profit from the business of the plaintiff.
What were you doing when the defendants number 1 and 2 entered?
No, my case is I am the landlord. I am the landlord of the premises. My case is, and also defendant number 1 and 2 case was in the trial court, that in 2010, the original tenant surrendered the tenancy, and then I inducted 1 and 2 as a tenant. And he, since 2010, he is.
Surrender of tenancy, that is a previous chapter. That we are not concerned. Let us take that defendant number 1 and defendant number 2 was inducted by you.
Yes. Then, and the plaintiffs are
in the year 2010.
2010.
Prior to the death of your husband, prior to the death of the husband of plaintiff number 1, or after the death of
prior to that, because
so
plaintiff plaintiff's husband transferred it, surrendered, and told me to give it to his brother, defendant number 1 and 2, during the lifetime of the plaintiff's husband. It was done. That is the grievance, and they have accepted from 2010. They are not in possession. Your Lordship will let me read, and what is the prayer? Your Lordship, what is their case and what is the prayer? The law, that is page 6, Your Lordship. The law of the land does not permit the defendants to carry on unlawful business with late machineries of the plaintiff. Thus, at both the instances on 29/11/19 and thereafter on 13 March 20, when the plaintiffs went to take custody, Your Lordship will kindly know what was the status of the plaintiff. He was not in possession, he wanted to take possession. When the plaintiffs went to take custody of their own machineries and shop room, the said defendant number 1 and 2, in connivance and conspiracy with defendant number 3, tried to resist the plaintiff number 2 to 4, and they also used filthy language to the plaintiffs and threatened them with dire consequences. The plaintiff states that the said defendants are also connected with antisocial elements in the said locality, and until and unless the defendants are restrained from creating any hindrance to disturbance to the plaintiff for putting a padlock in the said premises, the plaintiff will suffer irreparable loss and injury. The cause of action of the suit arose on 29/11/19 and 13/3/2000, when the plaintiff went to the said shop room and tried to close the shop room under the name and style, which is the shop room.
Counsel, so through the injunction,
at Kalisi,
through the injunction, you are seeking the relief.
Through the injunction, they have been put into possession. Did we buy an ad interim order? When the prayer is not that, they were not seeking possession of the property. Can you see the prayer of the plate? What is the prayer? Declaration that the plaintiffs are owner of the said shop room, an establishment under the name and style of Sharma situated and so, along with the late message. Permanent injunction be issued restraining the defendant from interfering in any manner whatsoever from putting padlock on the premises, being the shop and establishment under this. They just wanted to close the shop, put a padlock. That is the prayer in the plaint, and in the injunction also it is the same. And the court passes as something new order, and that also ex parte, and that is being made absolute right from the trial court till the appeal court. Kindly come to page.
Contested order.
Yes, and I have come up here in a revision because of that. Kindly
you have jumped the miscellaneous appeal?
Yes, I have filed a miscellaneous appeal also dismissed. Because of that, the court did not look into the plaint and the averments made in the plaint and the injunction. Your Lordship, kindly come to page 36.
You are representing, who is representing Jhunjhunwala?
Yes, I'm the landlord. Defendant number 3. Kindly come to page 36, the prayer. Under the circumstances, it is humbly prayed for following step. An order of injunction be passed restraining the respondents, particularly 1 to 3, from dealing with, disposing of, alienating, encumbering, creating any third party interest in respect of the shop room, not to create that, and then order restraining the respondent not to carry further business. These are the two orders they have prayed for with that environment. Now kindly come to the impugned orders. And the court passes mechanically, your lordship, the orders. First, your lordship will kindly come to the trial court order.
Page?
I'll give you. Certified copy, your lordship. না তার আগে করছি
An order passed on 18/4/23 is on under section 151 CPC.
No, there were several applications. The relevant one which I have challenged is the injunction. There were amendments and all. That is, your lordship will kindly come. Internal page 7 of the certified copy.
Order dated 18/4/23.
Kindly see. Yes, ordering portion. The ad interim relief granted to the plaintiff to the tune.
This has been passed under
Injunction. That was the disposal of the injunction application.
on contest.
Huh?
On contest.
Yes.
Everywhere section 151 is being found. Where is order 39?
Kindly come to page 1 order. Several applications were disposed of. Come to internal page 4. Your lordship has got that?
Yes, internal page 4.
At the bottom, after for order, then he takes up the injunction application. This is the impugned order. Order.
Let the case record be taken up for passing order in respect of the injunction application.
Yes.
Through amendment, what was sought for and what was allowed? Order 6 Rule 17.
I'll just. He allowed. It doesn't, your lordship, it takes up.
I'm appealing for the opposite parties number 124. I am the plaintiffs in the suit. I had filed an amendment application because the contention was raised by the defendant that my predecessor in interest, late Devkinath Sharma, had relinquished the tenancy. So I have, after the defense was taken, I had taken out an amendment application saying that after the this particular contention of 2000, the landlord had in fact issued an eviction notice on my predecessor in interest, thereby admitting that I was a tenant and I had not relinquished. I'll just read the paragraph. I have a copy of the amended
application.
I have the copy of the plaint which was amended. Only one paragraph was introduced. Paragraph number 15A. I may read this, that the defendant number 3 of the present suit, being the landlord, whom my learned friend is representing, issued eviction notice through his lawyer Sheikh Shahadat Kamal on 14th of March 2000 to Sri Devki Sharma, predecessor of all plaintiffs, in respect of the suit shop room, treating him as monthly premises tenant, and the said eviction notice defendant number 3 stated that on and from 1st of May 2000, the relationship of landlord and tenant between defendant number 3 and Devki Sharma shall absolutely cease and terminated and shall be incorporated. If my lord,
Yes, I don't dispute that.
1st of May
I don't-
2020.
the notice was issued on 14th of March 2000, and it was
I
contended,
don't dispute that
and it was contended,
for the present.
and it was contended that from 1st of May 2000, the relationship of landlord tenant
Terminates.
I don't dispute that.
That was his
I
contention.
take it that is the position. But what is the case in the
I
play?
have brought in this fact by way of an amendment.
Yes,
to the-
I am not challenged that order. You'll also that will be decided by evidence, on evidence. Now, but kindly see the injunction, what order has been passed. What your lordship has seen the plaint and the injunction application, prayers and the facts. That the shop is to be locked, restrained from, and these two prayers in the injunction application. Your lordship has got that? Kindly see the injunction.
And you are the defendants number 1, 2, and
3.
1, 2, and 3.
I'm 3.
Only 3.
Landlord.
And who are 1 and 2?
I'm saying they are the tenants, my present tenant.
Number 1. Number
Now,
1 has died.
kindly see what declaration they have prayed in the plate.
In respect of one shop room, how can be 2 tenants?
No.
One set are they?
No.
Other
What
set-
happened, your
May I
lordship?
indicate the facts, my lord, for my
No.
lord's convenience. My lord, my predecessor in interest, I am representing the wife and the sons. My predecessor in interest was a tenant. This is an admitted position. Now, my lord, it is my learned friend's contention that I have relinquished the tenancy.
1 minute.
So,
It is his contention earlier, not
Yes.
now.
not now,
No,
in 1999,
no.
I have relinquished.
It was his contention that you have surrendered the tenancy.
Tenancy I have inducted him.
And the tenancy, yes,
Subsequent to that, a suit was filed.
I had filed a suit as a legal heirs of the original tenant. Because my contention
That
is
is in
I had never
No,
relinquished.
eviction suit was filed by whom?
No eviction.
No
suit has been
suit,
filed.
no
Only
suit.
notice was served.
Yes.
Only notice was served. But no
That
eviction
is also
filed.
disputed, your lordship. That will be decided in the suit.
If my lord gives me
But
5 minutes, I'll explain the facts.
A easy
No.
matter is being made complicated.
Yes, my
The
lord.
Nothing-
question is, my submission, your lordship, my submission is very simple. What is his case in the
No,
plate?
let me hear one by
Yes.
one. Otherwise,
Fine. I'll talk.
My submission is in the plaint, your lordship. The case is there, stated by the plaintiff, and the prayer has been made. Injunction application same. What is praying in the injunction application? Kindly see.
let us complete the hearing today.
My lord, I am ready to do that. Although I would have stated, my lord, that certain documents have been referred to but not annexed to this
Not part
petition,
of the
I would have asked for a prayer to make, my lord, file
Those-
an affidavit.
Those which have not done.
I would have prayed for filing of an affidavit because I will show from the petition itself that they have made certain statements, although they have not annexed those documents. Those documents would be relevant, but if my lord wants, I can argue it without affidavit. I'll leave it to my lord.
It was
It is up to them.
My lord. I leave it to
It's
them.
the
and my
court
lord's
of record. This is a court of record, your lordship. And whatever documents is there in the trial court, filed by the parties, I can refer to, without an affidavit. That is the rule.
The court seeks no document. It is up to you
Yes,
to
if
provide.
it is required,
If you have
if it is
mentioned it,
required,
If you have mentioned it in your petition,
No, I have not mentioned, what I have mentioned, what I have mentioned in my revisional application, I have annexed.
No, my lord, I'll just indicate one
no, no,
paragraph.
no, 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 no.
It has been
No, no.
mentioned and it has not been annexed.
No, no, no.
I'll leave
They are
it.
the petitioners.
Yes, my lord.
It is his submission that whatever has been stated,
Stated in the revision application, I have annexed.
revisional application have been annexed. But
That's
so
contrary to my lord, the petition.
whatever it might
one
be,
paragraph.
whatever it may be, whatever it may
Because
be.
that document is in my favor. That's why it has not been annexed. Yes. I wanted to just one paragraph. If my lord sees one paragraph, not more than that. Kindly sees paragraph 15 of the petition once. And if my lord says, I won't say another word. Kindly sees page number 8, paragraph 15. Because it has been his contention that I had relinquished the tenancy in 1999. I've already spoken about the eviction notice. Amended plaint is not on record. Now, secondly, kindly see page 8, paragraph 5.
The appellant
petitioner states that during the hearing of the injunction application, the plaintiff respondent, that is me, herein produced a purported rent receipt for the year 2003 for the said shop room alleged to be issued in the name of Devki Sharma by the appellant petitioner. The appellant petitioner states that a copy of the said rent bill was not served on the learned advocate of the appellant petitioner. The said alleged rent receipt appears to be forged and fabricated.
Yes.
So he has not been served, but the learned trial court has it. And without being served, he's contending it is forged and fabricated.
Yes.
And that document is not before mine. And
Yes.
that document is of 2003.
Did you not get the opportunity to file an objection to the
Yes, I have
application?
filed and I have stated that it is forged. What further I can do?
What the court did?
Court has not adverted to that. Because that will be the issue in the trial court, where I have prove it is forged or not by if the original comes in on the record. They have to place the original.
Whether it is forged or not, that will be considered
Evidence.
Now, on the prima facie, on the face of the document, we will have to adjust as regards to the injunction application.
What is stated in the plaint and what is the prayer in the plaint and injunction, that the court has to consider, not outside that. So, Your Lordship, for that reason, I was placing the injunction application and the prayer. That is relevant. Because what is the injunction application and what is the prayer made in the injunction application? And the court passes a something different order, where the plaintiff has not claimed that relief. He admits, because I placed, Your Lordship, in the plaint it is averred they wanted to go and lock the shop room on 2 occasions. They were not allowed to enter in.
Now, what do you intend to place?
Now, kindly see the prayer in the injunction application. Page 37. What are the prayers?
Yes.
An order of injunction be passed, restraining the respondents, particularly respondent 1 to 3, from dealing with or disposing of or alienating and or encumbering or transferring the tenancy rights and or causing any third party interest in respect of the shop room. Your Lordship has got that? His prayer is that the machines and nothing will be disposed of and not to create income. And kindly come to the next prayer. An order restraining the respondents not to carry further business. Not to carry any business with the missionaries. And what is the order passed by the court? And in the plaint also, Your Lordship, it's same thing. They said that on 2 occasions they went to lock the shop room, they were not allowed. Meaning that they are not in possession of the shop room, the plaintiffs. And they admit that in 2010, their predecessor, that is father, handed over to defendant number 1 to run the business, and since then they are running the business, not paying any usufruct from the shop room. That is the case in the plaint.
So, what documents are you relying upon?
No, I'm not. I'm relying on the plaint and the injunction application of the plaintiff.
Only the plaint And
Plain, what is the prayer and what the court passed? What is the case of the plaintiff and what the court has passed the order? I'm challenging that. Your Lordship has seen?
Impugned order.
Yes, I'll come to that. That is my grievance. Your Lordship, it's a court of record. What is there on record? Something from outside of this. Kindly come to page. Page. Kindly come to page 4. Internal page 4. Trial court order. Your Lordship has got that? Second part.
Last, the brief facts of the plaintiff's case.
The brief facts of the plaintiff case is that the deceased husband of the plaintiff number 1, namely Devki Sharma, was inducted as tenant to the suit shop room by the father of defendant number 3 in the year 1982 by dint of tenancy agreement dated 22/9/82. And subsequently said Devki Sharma started to run a business in the name and style of Sharma Engineering and Wire in the shop room. The deceased husband has also brought 2 lathe machines for the smooth running of the said business. After the demise of her husband on 7/10/2010, your Lordship will kindly note this date.
7/1/2010.
2010. The plaintiff led the defendant to supervise the business of their predecessor. And the defendant took to pay some money to the widow, plaintiff number 1, and her minor children. But gradually, the ill-motivated defendants.
Learned counsel, the plaintiffs led the defendants to, that is you.
Defendants 1 and 2.
Run the business.
Run the business.
To supervise the business of the predecessor. Yes.
Predecessor. But then, and to pay some money. That is there. But gradually, ill-motivated defendants, next page, your Lordship, depriving the plaintiffs and using the said machinery, started to run the business for their own benefit. The plaintiffs tried to close down the said business. Your Lordship, what was the grievance of the plaintiff? He tried to close down the business. As well as a shop room by law.
Presently, it is being run by you.
Yeah, it was no. Now the plaintiff, because of the interim order, the plaintiff has taken possession. That is my grievance.
Let us continue.
That is my grievance, your Lordship. By dint of the interim order, he has got possession.
The plaintiffs tried to close down the business.
By lock and key, firstly on 29/11/19 and again on 13/3/2000. But the defendants, your Lordship, restrained them vehemently. However, the plaintiff could not take any legal step against them because of the prevalent lockdown caused by the pandemic outbreak of COVID-19. It is the apprehension of the plaintiff that the defendants may dispose of the late machine. Your Lordship, kindly note that. What was his grievance? Late machine and disposes the plaintiff from the shop room anytime. During the hearing, learned advocate for the plaintiffs have referred and filed certain original documents attached to the frisk. They are following: 1 unregistered tenancy agreement, 2 tax receipts, 1 pro forma invoice, 1 power of attorney, death certificate of Devki Sharma, 1 photocopy, e-copy of electricity bill. The plaintiffs, by filing instant injunction application, has prayed for relief to the effect that the defendants should be restrained. Your Lordship, the prayer. Restrained from dealing with or disposing of or alienating or transferring the tenancy right or creating any third-party interest in the respect of the suit shop room, and restraining the defendants from carrying out further business in the name and style of Sharma Engineering and Wire, and using the machineries of the plaintiff and an order that the plaintiff be entitled to close down the business. These are the reliefs he has claimed. Your Lordship, kindly note this. One is not to deal with the machineries, not to transfer, alienate, close the shop room, and the business. This was the plan. Defendant number 2 in his written objection has contended that plaintiff by suppressing the material facts of title suit number so and so, and out of jealousy to notice that the defendants 1 and 2 are earning their livelihood from the suit premises has filed a false.
There was earlier title suit.
Yes, by the
79 of
defendant
2019.
1 and 2, by defendant 1 and 2 against that. Now, Kali, defendant number 3, that is the landlord, denying all allegations raised by the plaintiff, has contended in his written argument that the plaintiff had procured an ad interim injunction order by misleading the court, whereas the predecessor of the plaintiff has already surrendered his tenancy in favor of defendant number 1 in the year 1999. During hearing, learned advocate for the defendant number 3 has argued that the landlord shall not transfer the tenancy, then why he is not restrained from entering into his own tenancy property. He has submitted that it is not possible to seek for closing down a business in the form of temporary injunction. He has lastly argued that the plaintiffs are not in possession, this is the specific case, over the suit property, then the question of their being dispossessed does not arise, come into play. Learned advocate for the defendant number 2 has agitated that the injunction application in title suit number so and so was not disposed of on merit, and plaintiffs have obtained the ad interim injunction order in this suit by misleading the court. He has argued that the landlord is the best person to decide who is his tenant, and in the present suit, defendant number 3 himself denied the tenancy of the plaintiff. Then how they are entitled for a temporary injunction, especially when they are not in possession over the suit property. By drawing the attention of this court towards the document filed by the plaintiff, he has further claimed that those are documents of afterthought. In reply, the learned advocate for the plaintiff has argued that the documents so produced by the plaintiff and the defendant as well as are required to be proved at the time of trial. Your Lordship, this is at the trial. At this primitive stage, this court, while judging temporary injunction application, is to see whether the essential ingredient to allow the application was met up or not. Besides, the facts stated by the adversary are beyond pleading, and the electricity connection over the suit property is still in the name of plaintiff number 1, and the eviction notice was never acted upon by them. Perused, heard, considered. On consideration of the instant application, written objection, plain written submission, statement, submission of both sides and an entire case record, this court is of the view that none of the parties shall be prejudiced if the ad interim order so passed by this court be made absolute till the disposal of the suit.
What was the ad interim order?
Yes, that I am coming. It is there.
Let us finish this one.
Yes.
Disposal of the suit in order to
prevent further breach of peace over the suit property. This is because the allegation and counter allegations raised by each set of the contesting litigants require exhaustive trial, and this court at this primitive stage does not find it feasible to make any remark over the same. This will lead to prejudging of the suit only. Besides, the plaintiffs show their primary case to face the trial and the balance of convenience and also this. Now, kindly come to the ordering point. Hence, it is ordered that the ad interim relief granted to the plaintiff to the tune that the defendants are directed not to dispossess the plaintiff from the suit premises. This is my grievance, Your Lordship. Because the plaint and injunction application, they are not in possession, they are not prayed for. This is my grievance. And taking advantage of this order, they have entered into taken possession by this interim order. The court has completely overlooked what is the case of the plaintiff, what relief the plaintiff is claiming in the suit and the injunction application, and passes an order at this stage. This order was passed ex parte, and that is being made absolute. This portion of the order I am making.
Not to change the nature and character of the suit shop room.
That let it be there.
Machineries are not to alienate.
Alienate that portion, I am not aggrieved. But how can he say that not to dispossess the plaintiff? Taking advantage of this, the plaintiff has entered into the shop room. When admittedly, after the death of their predecessor in 2009 or 10, they are not in possession. Their only grievance was that they wanted to close down their shop. They were not allowed to close down the shop. And the defendants are trying to dispose of the machines. With regard to that, I'm not aggrieved at all. Let that order be there. But how can he get
had you produced that which you have said, that surrender?
Yes, Xerox copy.
Whatever might be.
But that is there. But that will be a
Where is that? Where is that?
I don't have it here. I'm not, Your Lordship, I'm not on that. They have.
The court is not to go through
Yes,
those
yes,
documents.
yes. I'm not on that. What I'm submitting now, I'm not having that.
Only on oral submission can it be decided?
No. No. What I'm submitting, Your Lordship, leave it aside.
Why didn't you produce place the documents, photocopy of those?
Yes, I'll place that. I'll place that. I placed it in the trial court. I've not placed it here.
When?
Next week, Your Lordship will fix it. Next week, I'll place it.
Don't you have in possession?
I don't have it. I have only this. The lower court records are not. That is the difficulty.
Anything more to be submitted?
Your Lordship, that.
I don't think anything more is to be submitted apart from the documents. That sole document.
Yes. Now, my submission is only that. What is the prayer in the plate and this?
So according to you, the plaintiffs had surrendered in the year 2020. Their predecessor.
That they are disputing.
1999.
But no,
1999.
That they are disputing. If it is
I'm saying according to you.
My case.
According to you,
my case.
The plaintiffs, the predecessors of the plaintiffs had surrendered during the year 1999.
And then I inducted and told me to induct his brother. I inducted his brother. That is the defendant number 1.
That is chapter 2.
Yes.
Chapter 1 is not related to chapter 2 is not related to chapter 1.
Yes, surrender and then induction.
With the surrender, chapter 1 closes.
Yes.
Chapter 2 commences.
Yes.
By induction of his brother, whatever, he's a separate identity.
But at the present moment,
now it is in possession of the plaintiffs.
Which? Yes.
Now it is in possession of
possession of my case is that plaintiff has not come up to protect his possession. They have not come praying for the state.
According to you, they were not in possession. Instead, his brother was in possession. His brother has been dispossessed.
They have stated they are not in possession. The plaintiffs are not in possession.
Which paragraph? Which paragraph?
10 of the plain, page 21.
Place it, place it.
They are not in possession. They are not there. That is their case. The plain case is that.
No, I am unable to understand the first line. Interpret the first line. What is written there?
The defendant number 1 was running the business unlawfully
number 1
of the plaintiff.
Step by step. The defendant number 1 was running the business unlawfully of the plaintiffs.
Of the plaintiffs.
What does it mean? Of the plaintiffs? What does it mean? Of the plaintiffs?
Plaintiffs out of the fund of the plaintiff after 7/1/2010, The lathe machines of the plaintiff. This is the plaintiff, your lordship.
The plaintiff,
The
we'll have to-
plaintiff being owner of the said business was
we'll have to
deprived
mold according to us. The plaintiffs being the owner of the said business was
deprived from being paid a single
single
penny.
Acha.
Kindly see.
Dependent number one continued to use the lathe machines.
Lathe machine.
And the business whose owner are at present the plaintiffs herein. Okay.
Yes. So your lordship has seen that.
Third learned counsel.
Now 11, paragraph 11 specifically.
What is more written there?
The said business cannot be run by the defendants.
Huh.
So the plaintiffs are not running the business.
Obviously, cannot be done by the
Defendants. Their claim is that, and for that reason they wanted to close down the business.
According to you, the cannot be done means present.
Yes.
Present tense.
And with this, your lordship read the prayer. They want to close down the shop room.
Put a padlock.
Put a padlock and not to alienate its use the machines for that.
Let they be heard first. Oh, both of you are brothers.
We had issues before we have resolved it.
We have settled.
Now, may I just address?
Only thing he didn't place the order of the miss appeal. That is the.
Yes, I'll also place that.
I'll indicate, my lord.
Because otherwise, again, my learned senior friend has to start.
I'll place that, your lordship. Your lordship will come.
বসো না তুমি বলতে স্যার প্লেস করুন
That is, your lordship will kindly see.
Order dated 14/11/24.
Yes, yes.
Place it.
Appellant and respondents have filed Hajira before this court. The record is taken up for passing order upon the state petition filed by the petitioner appellant and hot on the last day. Well, the learned advocate for the appellant had during the hearing of his state petition submitted that the impugned order for injunction granted by the learned trial court to the respondent is not proper, as the respondent numbers 1 to 4 were not in possession of the shop room, and that the defendants 1 and 2, the pro forma respondent number 5 and 6 of this appeal, were in fact in possession at that time. He further submitted that the instant appeal has been admitted and there are good grounds for him to succeed in this appeal. But unless the impugned injunction order was stayed, his success in the appeal would become infructuous, as the respondent will be able to gain possession of the shop room. And this apprehension has been, I apprehended that by dint of that interim order, he will get into possession. He has got into possession. The learned advocate for the respondent 1 to 4, on the other hand, submitted that the submission of learned advocate for the appellant was wrong, as the respondents were already in possession of the shop room, and there was some misunderstanding between respondent number 1 to 4 and pro forma respondent, which has been amicably sorted out between themselves, due to which the pro forma defendants are no longer trying to forcibly occupy the shop room. Unlike the appellant who is trying to do so, for which the respondents have been granted injunction in this matter against the appellant. He submitted that the injunction order was tenable considering the facts of the matter and hence need not be stayed. Or the both sides. It appears from the submission of both sides and materials on record that the respondent number 1 to 4, being the plaintiff in the trial court, are presently in possession of the suit room. That is, after the interim order passed by the trial court. Presently in possession. Scheduled shop room, and they have been granted ad interim injunction in this matter by the learned court against the appellant and other defendants, which was subsequently confirmed and made absolute after hearing both sides.
Not after the ad interim order. After the order being passed on contest.
Yes.
After it being made absolute.
Yes.
Thereafter, they re-entered.
Yes. After the injunction order was made absolute.
Thereafter, they re-entered.
Not re-entered. They entered. Re-entry and entering is two different things, my lord.
They entered. Okay.
They entered into, and they admit that in the appeal court.
With police help or without police help?
No, by force.
How can it be?
Yes, Your Lordship,
That
they have numbers are with them. We don't have the numbers.
Let us now proceed.
Trial court against the appellate and the other defendants, which was subsequently confirmed and made absolute after hearing both sides. The injunction order has spelled that the appellant could not dispossess the respondent from the shop room and shall not change the nature and character of the suit property, and would not alienate, transfer the alleged machine in the said room till the disposal of the present suit. Such is the present state of affairs. There is apparently no prima facie case for stay.
Upon the impugned order, in fact, stay of the impugned injunction order
It
will
rejected.
result in disposition of the present
But the
occupants
court
of the
did-
property.
The court did not consider consider at all my grievance that the injunction order that was passed. At that point of time, the plaintiffs were admittedly not in possession.
That has not been considered.
Considered, and Your Lordship will kindly consider, and in the appeal court it has been proved, and that has been recorded by the appellate court also, that they have now in possession. That's true. That could only happen after the order passed by the trial court.
After the injunction order being made absolute.
Yes, Your Lordship, and Your Lordship,
Let
the
us
court,
now hear,
no,
hear them.
one more. The appellate court did not consider the plaint and the case of the plaintiff. What was the prayer in the plaint and the injunction application? Both the court overlooked this without application of mine.
Learned counsel.
My lord is exercising jurisdiction.
Actually, what happened? Your Lordship was asking for police help. With police help or not? Page, kindly come to page 2.
That is not the
No,
prime
because
issue.
they sought
Brother.
police help. That was rejected. Still they got it.
My lord is exercising jurisdiction under Article 227 of the Constitution of India, not that of the first appellate court, not that of the second appellate court. So, my lord, here, my lord, whenever my lord is exercising this jurisdiction, there has to be a patent illegality or some jurisdictional error in the order.
Patent illegality.
Patent illegality. On the face of it, there is no scope of any doubt that a major illegality has happened. Then only my lord will exercise the jurisdiction. Now, under Order 43, certain orders have been made appealable, certain orders are not appealable. Whichever is not appealable, my lord, to supervisory jurisdiction may be invoked, provided, as I said, patent illegality. 3 stages I have won. This is the 4th attempt to dislodge that order, that interim order that I am enjoying. Now, what is the scope of this application before my lord? I had filed a suit.
That is the contention.
Yes.
His contention is all the 3 stages have not been correctly.
That would be a question on merit. My lord has seen the entirety of the orders.
That is now.
Now, today, my lord, I file a suit. I get an interim order, ad interim order. I will refer to the brief, but I'm just.
Because we have only 6 minutes.
Yes, I will explain the scope within those 6 minutes. Thereafter, if my lord wants, I'll come back on next Friday. So, my lord, I had filed a suit. I got an ad interim order in my favor. Thereafter, written objection was filed, which has not been annexed here, not annexed. Written objection filed by them, not annexed. Nonetheless, after contested hearing, the interim order was confirmed in my favor. They preferred an appeal. And in that appeal, they filed a stay application saying the interim order must be stayed. My lord has seen the
Stay was not granted.
Stay was not granted, but the appeal is still pending. They are not pursuing the appeal. They instead want that interim order of stay, which was refused, to be vacated by my lord. They are not pursuing that appeal. So this is because injunction order 39 rule 1 and 2 is an appealable order under order 43. So that's why they filed the misappeal. Misappeal stay was refused. Now they have come up here. So this is basically challenging an interim order under order 39 1 and 2. Now, second of all, patent illegality. The major contention from what I hear from everywhere in the impugned order or in the order which was passed in the injunction application is that my plaint does not say that I am in possession. I have stated that my brother is running the business, so I am not in possession. How can there be an interim order protecting my possession? Now, what is my case in the plaint? I am not going to read it again. My lord has already read it. My case is that since a very long time, my husband and the father of the other plaintiffs was the original tenant. That is admitted. Nobody will be able to dispute that. That business was continuing. This is a shop room where a business is being, it's not a residential premises. Business was being conducted.
Devaki Sharma, the original plaintiff, passed away in 2010. The children were small. The wife didn't have much experience. So they said the brother of Devaki Sharma, the original tenant, whom my learned friend is presently representing, he has also passed away. They were supervising the business, running the business from the shop room. Now I put this question to myself, does that mean I am not in possession because somebody else is helping me run the business? Have I stated anywhere in the plaint, I am not in possession? Then my prayers would have been for recovery of possession. I have not stated that. What I said, after the death of my husband, my husband's brother was helping out with the business and they were not giving any money. When they were not giving any money, I wanted to exercise my right that I am the tenant of the property. I will close down. Close down meaning putting on a padlock. They stopped me. I filed a suit. Does that mean I am not in possession? Today, my lord will see so many shops all around, near Amore, Monginis. The shop room owner does not run the business. There are always some sort of a manager or some service people who run the shop, who open it, who lock it. Does that mean they are in possession and the actual shop room owner is not in possession? This is the crux of the matter. Today, I am in possession. I wanted to bring in documents to show that the trade license of the business, even 2025, 24, 23, 22, all of these years, it has been in my name. They are saying that I have relinquished my predecessor in interest, Devaki Sharma, had relinquished the property in 1999. They have not annexed the written objection deliberately. My lord will not find any reference of any document on which reliance was placed before the trial court or the first appellate court that yes, there is a document has been produced which shows relinquishment. No such document is there. Possibly that is why written objection has not been annexed. I have also amended the plaint as I had indicated. I have carrying a copy of the amended plaint if my lord wants. If I had relinquished my tenancy in 1999, why would they serve me an eviction notice in 2000? I had showed the date.
This one is not the amended plaint.
No, amended plaint has not been annexed. I am carrying it if my lord wants. My lord will see that there is one order of 18th April 2023 in multiple applications were disposed of together.
Lord Counsel, then on the next day, on the next day,
My lord,
you provide all the amended plaint.
My lord,
and now it is up to you whether
may I suggest this, my lord? They have not annexed the amended plaint. They have also not annexed the written objection to the Order 39 Rule 1 and 2 application. This, I'm sure my learned friend would agree. Let them file a supplementary affidavit bringing everything on record, and I'll also put my affidavit in opposition. Kindly grants me that liberty. I'll bring everything.
Your Lordship, may I submit one thing? I have also impugned the ad interim order of injunction. Now, Your Lordship, the law is that at the stage of ad interim order, I can only refer to the plaint and the injunction application.
Plaint means the last plaint.
After the ad interim order, the plaint was amended, not before that. After the court already passed an order, the plaint has been amended.
My lord,
not before that.
Only one order has been impugned, my lord. First page of the petition.
By the order I have placed.
Order 6 Rule 17.
Yeah, no, the orders I was placing before Your Lordship, by that order it was amended. Ad interim order was passed long back. At that point of time when the court passed the ad interim order, and that order is being made absolute. Nothing plus or minus. That when that order was
prior to the passing of the order, injunction order being made absolute.
Yes.
They had filed the amended plaint.
No, that was passed by the order, by the same order, impugned order. In this order, it has been allowed. The amendment has been allowed.
No.
Yes.
Impugned order is that of the first appellate court refusing stay.
No.
Yes, that is the first paragraph. I am sorry, I have to interrupt.
Which is the impugned order?
It is 14th of November 2024. First page shows that.
Which is the impugned order?
I'll show that.
14/12/24, 14/11/24.
Kindly come to that is 14/18/4/2023.
How can that?
Trial court order.
If that is impugned, then that would be an appeal.
Is that the impugned order?
I'm not. Yeah, no, that is not the impugned order, because by one order, several applications have been allowed.
Impugned order is dated 14/11/24.
No, that is
14th November.
that
11,
is
ठीक है,
the misappeal.
Yes,
Yes,
against
I'm-
against which you have come up.
yes, that is the misappeal.
Yes,
But trial court, your lordship, when the amendment was allowed, at that point of time, when the trial court,
prior to the passing of this order dated 14/11/24.
yes, that amendment was allowed.
Amendment was allowed.
That was allowed.
So let the amended plaint and the written objection, if any other.
I don't have the amended.
My lord, kindly grants
Yes.
me liberty to file opposition. I'll bring everything on record, my lord. Kindly grants me to.
When will you be able to file a supplementary affidavit? Supplementary affidavit?
With regard to your lordship?
The written objection, amendment of amended plaint.
Amended plaint, I don't have it.
Written
You have the
objection.
written objection.
Written objection which you had filed before the trial
Which will be
court.
filed.
Yes, that I can file.
When?
Your lordship will give me 2 weeks time.
2 weeks.
He'll not be here next time. Your lordship will kindly fix it. Give me time next Friday. You give me your lordship Monday or Tuesday. That will do. Because he's no. Making affidavit.
Friday week.
Actually, his daughter's
No,
Madhumik, your lordship.
that's okay.
2
So-
weeks, your lordship.
So, after some submission, after the completion, after some submission being made by the learned counsel representing the petitioners, no?
Appellant. Petitioner. Petitioner one.
Sole.
Petitioner. It transpires that in this list, amended plaint has been filed prior to the passing of the order, prior to the passing of the impugned order, that is the order passed in the miscellaneous appeal, dated 14/11/2024. As such, the amended plaint is required to be filed and written objection filed by the petitioner before the trial court. Written objection against the injunction application filed by the petitioner before the trial court has also not been furnished. That is also required to be taken into consideration.
Your
In
lordship,
such
I don't have the amended plaint. So
That they will-
if he,
I will
if he-
provide. I will
don't
provide.
have the amended plaint. It
No,
has not been furnished.
petition is only there. After they amended,
How could they have filed before the court?
no, amended. No,
Without, serving
your
copy
lordship
upon
has experience of trial court. The original plaint is to be amended. And then an amended plaint is to be filed.
Huh.
But that has not been served.
The court won't accept the amended plaint until and unless it is served upon the adversary.
But we have been served with the application.
Maybe.
So
My lord, if they don't provide, we'll provide.
kindly
Option?
you can provide me, I'll put it in my.
I will
in
No,
the-
no, they will provide
My
through
lord,
the
do that.
through the affidavit in opposition.
My lord.
Okay.
And the learned counsel representing the petitioner seeks a fortnight to provide the same. To provide the same. Full stop. The petitioner is granted the fortnight to file supplementary affidavit. Full stop. At this stage, the learned counsel representing the petitioner further submits that he does not have the amended plaint, copy of the amended plaint.
That which is disputed by the opposite parties, my lord. Because the submission is being recorded, then it will look like I actually haven't, but I have. My lord, so kindly record the submission and also records my objection.
Which has been disputed by the learned counsel representing the
Opposite parties number 124.
1 TO2
24.
124. Full stop. In such circumstance, let the learned counsel representing the opposite parties number 124 provide the amended copy of the plaint along with the affidavit in opposition let the affidavit, copy of the supplementary affidavit be provided to the learned counsel representing the opposite parties, both the sets of opposite parties, on or before, on or before 13th, February. On or before 13th.
His daughter's examination is
Ah,
2 weeks I have paid.
2 weeks, 6th and 13th. Oh, the 20th. 20th. On or before 20th. On or before
12th it will, the exam will get over.
on or before 20th.
Oh. I'll do it on 13, 15, 16 I'll submit.
On or before 20th, full stop. And affidavit in opposition to be filed within a week thereafter, full stop. Let the matter appear on 27th of February.
I'm grateful to my lord.
That is civil revision day.
Huh?
27th is civil revision.
May or may not be.
Your
Not
Lordship,
calculated.
the last time your Lordship said one week it will be
That I
second
intend.
appeal, 1 week
That I
civil
intend.
revision.
That I intend, but may or may not be as per calculation. I have not calculated just now.
No, there will be 4.
Passed over. Passed over matter. Where's the other side?
Grateful.
Learned counsel.
My lord, I was, my lord, on my legs, my lord. Another put to my lord.
When you can submit.
Next
When you
Friday
can-
itself, my lord. Next Friday at the top, my lord. I'll be there.
নেক্সট ফ্রাইডে কি বলে কিছু আছে, টপিক কিছু আছে? যদি টপিক কিছু থাকে, যদি শুনুন, যদি অর্ডারে টপ বলা থাকে বা 2 বলা থাকে, তারপরে এটা দেবেন, ঠিক আছে? If there is anything appearing in the top, thereafter it will appear.
My
This
lord,
one.
one thing, my lord. CO 1513, it is that CO has been served, the copy is served upon us. But next CO which they
I'll produce.
that was not
I'll
served. my
I'll
lord.
He is submitting that that will be provided to you.
By Monday, I'll do it, my lord.
May I have a one-line order?
No.
May I have the take back the copy of the print?
দিয়েছিলেন সেটা ফেরত দিয়ে দিন। দিন দেখবেন।
Now kindly made it top. Otherwise, my lord, I am suffering blanket order of stay. And the party who is challenging, their predecessor filed Solenama.
Lord, may I indicate, my lord, Solenama and other things, my lord, I do not have, my lord, any instruction or in my record, my lord. If my learned senior friend, my lord, wants to place it, my lord, a
Solenama is
copy be given to me, my lord.
My lord, Solenama is indicated in the order itself. Parties who presented this CO
At the time of hearing,
my lord.
the court requires everything. It is up to the learned counsels to provide. If not provided, then everything will be adjusted as per the documents which are available.
I'm for the opposite party, my lord, and Solenama is his client. How could I provide? It is the Solenama filed by his predecessor, his father, and now he is challenging that decree. Curious enough, the Order 23 Rule 1, my lord, that compromise can't be challenged. When Solenama filed 1X came after his death, why his son challenged that ex parte decree? Ex parte and, my lord, compromise. Partly ex parte, partly compromise. And that Solenama he is demanding from me. Solenama used
My
by
lord,
his predecessor.
The premise of the revisional application is, my lord, completely else, my lord. My lord, why the Solenama is, my lord, if at all there is any Solenama, my lord, I'll take instruction regarding that, my lord. I'll come back.
Well, kindly made it top, my lord. Otherwise, my lord, I am, my lord, suffering blanket order of stay.
Well, grateful.